Good afternoon, everyone. Welcome to the Appellate Division First Department oral arguments for March 2, 2021. I will now call the calendar. People v. Jamie De Jesus.
Good afternoon, Your Honor. On behalf of Mr. De Jesus, Dana Wolf.
You have 8 and 2.
Thank you, Your Honor.
Good afternoon, Your Honor. On behalf of the people, Jennifer Watson.
You have 8 minutes. Medina versus Nycha.
Good afternoon, Your Honors. Greg Friedman for appellant.
7 and 2.
Thank you.
Mr. Lawless, you here? Okay, so he was having issues. He had not apparently answered on the first calendar when Ms. Rojas called the calendar initially. We sent him an email, so hopefully he'll be able to join us at some point in time. Michael versus Jennifer, submitted. Abraham versus Dutch Broadway.
Good afternoon, Your Honor. Elon Wurtzel for the appellant.
5 minutes.
Thank you.
Good afternoon. Good afternoon, Honor. Sean O'Shaughnessy for the respondent.
3 minutes. Bacchus versus Bronx Lebanon Hospital.
Good afternoon, Your Honor. Seth Cornwell for the appellant.
8 minutes.
Good afternoon, Your Honor. Jason Turkin for the respondents.
5 minutes.
Thank you.
People v. Juan Gonzalez is submitted. Anderson Kill versus Board of Managers, submitted. TKS Realty versus 391 Broadway. Appellant?
With
Hello? TKS Realty versus 391 Broadway. Anybody home?
Responded, Your Honor.
Responding, you have 7 minutes. The appellant present. Okay, well, the appellant has 7 minutes as well. Aaron Law versus New York City Department of Education.
Good afternoon, Your Honor. Joseph Aaron for appellant.
10 minutes.
Jeremy Schwader for respondent, Your Honor.
10 minutes. Pacelli versus Peter L. Cedeno and Associates.
Good afternoon, Your Honor. Justin Kelton for the appellants.
5 minutes. Respondent. Rizzo versus Estate of Prolifoni.
Katrina Jones for the petitioner.
8 minutes.
I'd like to reserve 2 minutes for rebuttal, please.
Sure, 6 and 2.
Thank you.
Gregory Casino for the estate of Dr. Polifroni.
4 minutes.
This is Danielle Bennett with Coster, Brady, and Nagler for Dr. Anna Rose Polifroni.
5.
Thank you.
People v. Otha Williams, submitted. Palermo versus 7 West 21 LLC.
Michael Zhu for plaintiff.
5 and 2.
Thank you.
Roxana Krasovitskaya for respondents.
5. People v. Santino Guerra.
Patrick Updike for appellant Guerra.
7. I apologize. People.
Good afternoon. Charles Wan for the respondent.
5. Integon National versus Lynn, submitted. Correa versus Mana Construction.
Good afternoon, appellant.
4 and 2.
Good afternoon, John Moore for the city respondent.
4. Sacman Enterprises versus BOM Chesterfield.
Good afternoon, Your Honors. For the appellant, Sacman Enterprises.
6 minutes.
Good afternoon, Your Honors. Kristen Pendergrass for respondents.
Good afternoon. 6. Brannick International versus HPD.
Good afternoon, Your Honor. David Haberman for Brannick.
5.
Thank you, Your Honor.
Wamaka GB for the respondent.
5.
Thank you.
CSC Holdings versus Samsung Electronics.
Good afternoon, Judge. Jim Catterson, request 7 and 3 for the appellant.
Good afternoon, Mr. Catterson. 10.
If I could reserve 3 for rebuttal, Judge.
Certainly, Mr. Catterson, that's 7 and 3.
Thank you.
Richard Mark, Gibson, Dunn and Crutcher for the plaintiff respondent, CSC Holdings LLC.
10.
Thank you.
NYCTL 2015A versus Masson is submitted. Stengel v. Vance is submitted as well. So in this virtual world, it's very important that everyone keep their mics muted unless you are actually speaking. Also, we always ask that you not speak over the judges, but even more importantly, again, in this virtual setting. First case for argument is People versus Jamie DeJesus.
Good afternoon, Your Honors. May it please the court, Dana Wolf on behalf of Jamie DeJesus. I'd like to discuss the two identification issues today. The prosecution's case at trial hinged on two identifications, one from eyewitness Natalie Ramos and the other from the decedent's sister, Ashanti Rodriguez. But here's the problem. Both of these witnesses were interviewed by the police immediately after the shooting, and neither one of them could make an identification. Neither of these witnesses made an identification for over 2 years after the shooting. Both of these witnesses only identified my client after the prosecutor called them and specifically asked them to come to the office to prepare to testify against my client at his trial. The trial court failed in its fundamental responsibility to keep this unreliable information from the jury.
When you say unable to make an identification, you're referring to the fact that there was a surveillance video. Is that correct? Is that the identification that you're referring to?
The prosecutor so both witnesses went to the police precinct after the shooting. Ms. Ramos about a week after, Ms. Rodriguez 5 days after her brother was shot.
Which witness was actually present at the time of the shooting? Was that Ms. Ramos? Is that correct?
Ms. Ramos, that's right.
So Ms. Ramos was actually present at the time of the shooting. Was she not also the witness who stated that she had initially stated that she did not identify the defendant as the shooter because she was fearful?
That's what she told the prosecutor. We don't have a lot of information because there was no hearing here, but the sequence of events is roughly as follows. A week after the shooting, she was present for the shooting. A week after the shooting, she went to the police precinct. She went there for the purpose of helping them with the police investigation. She did not make an identification. The police then make efforts to arrest my client. They paper the neighborhood with 150 posters that say Jamie DeJesus is wanted for shooting and killing Alexis Rodriguez. They arrest my client.
It's a little bit more than that in terms of the iCard or the wanted posters. That was also based upon, there were other witnesses. There was a Mr. Polino, I believe, as well, right? So there were other witnesses. It wasn't only based upon these two witnesses or Ms. Ramos. It was also Mr. Paulino, and it was also the surveillance video.
Well, a couple of responses to that. First, important background information is that the police arrested another suspect a block away in the direction that the shooter was supposedly fleeing, and they arrested that person because they matched the description of the 911 caller. And that person who they arrested was my client's half-brother, Lester Klassen. And they let the half-brother go because another person who was present said my client was the shooter. That person ultimately refused to come and put that identification under oath. So the person whose identification predicated the iCard never testified at trial.
But the issues that we're really concerned with as to Ms. Ramos first is the issue as to whether 71031B notice should have been given, whether it had to be given, but more importantly, whether there was in fact an identification procedure which would necessitate a Wade and or a Rodriguez hearing.
Absolutely. Question that this was an identification procedure. She's called by the prosecutor to come to the prosecutor's office to testify against Jamie DeJesus. She showed a video of the shooting, and at this point, she then purports to be able to identify Jamie DeJesus. We don't have a lot of information about what happened here because there was no hearing. But what we do know is very troubling. Now, it would not have taken a great deal of time to have a hearing. And I think what's important to remember is that the Court of Appeals recognized in People versus Marshall that it may occasionally be the case that in the course of preparing to testify, an identification may come up. And that's okay. It's not necessarily nefarious that somebody makes an identification when they're in the course of their trial preparation. But what the Court of Appeals said in Marshall is that that identification is subject to a Wade hearing the same way as if Natalie Ramos had made that identification the week after the shooting. There just needs to be a hearing to make sure that it's a reliable identification before the jury can hear it. We know that juries give enormous weight to identification testimony like this. And it's truly critical that juries only hear this information, this evidence, when it's been tested. We don't really know the relationship between Natalie Ramos and Jamie DeJesus. The court even precludes a Rodriguez hearing to establish their prior familiarity with each other.
I thought she stated to the detective that, or to the prosecutor, her statement was that she knew the defendant. She had known the defendant, I think, for over 7 years or something of that nature. She would see him at least once a year for a 7-year period of time in the neighborhood, and that she knew him. That was her familiarity with him.
Well, Your Honor, she didn't say she knew him. She's not from this neighborhood. She hangs out in this neighborhood, and she did say that she had seen him in the neighborhood. There's no information about her ever speaking to him. She doesn't know who his friends are. She doesn't know who he hangs out with. If she had come, this was just not adequate to sustain a burden out of Rodriguez hearing. But importantly, there was no Rodriguez hearing. There was no Wade hearing. This is a wholly untested eyewitness identification with no Wade hearing, no Rodriguez hearing. And we know that Natalie Ramos was not able to make an identification shortly after the shooting. It was dark. She testifies that there were not a lot of streetlights on page 325 of the transcript. She said that she saw Jamie DeJesus once a year, but she also said that years would pass by, a year or two. There's no testimony that they ever interacted with each other. She doesn't know who his friends are. And there's all of this critical post-event information. And as this court recognized in People versus LeGrand, witnesses, memory is malleable, and she may truly not have been able to identify the shooter at the time that she went to the police precinct and was only able to backfill her memory when she's inundated with neighborhoods with a picture of my client that say he shot and killed her friend, and she's called by the prosecutor to come testify against my client at his trial. We don't know.
This is Judge Scarpula. The flyers were way before she came to the prosecutor, right? The flyers were, and then your client was found in another state, right?
Right, Your Honor.
So
absolutely.
There's like years between those two events.
That's exactly right, Your Honor. There's years.
So how could you say that she was inundated right before she came in with pictures of this man being wanted for murder?
Well, no, Your Honor, that's not what I'm saying. What I'm saying is she made an ID before all of this stuff happened. She said she does not know who the shooter is. Now, maybe she was scared and the whole time she knew who the shooter was, and that's why she didn't make an ID. Maybe she actually didn't know who that person was because she didn't really have a relationship with him. And then she gets all of this information after the fact, including specifically, and what she says is the prosecutor calls her up and says, quote, "Jamie is here, I have to come in." And that's on page 336 of the transcript. So, all of the things that this court considers in terms of whether or not an ID is suggestive, was the witness told that there's a suspect in custody? Were the circumstances suggestive of guilt? There's no circumstance more suggestive of guilt than being called to testify against someone at trial and then making your identification in that context. And this is why it was critical that there was a Wade hearing or a Rodriguez hearing. And I see my time is up, so I'll save the rest for rebuttal.
I was going to say, you have
Thank
2
you so
minutes
much.
rebuttal. Thank you. People?
Good afternoon, and may it please the court. Jennifer Watson for the Office of Darcel D. Clark. The people respectfully request that this court affirm the judgment of the Bronx County Supreme Court because the trial court correctly found that no pretrial identification procedure was conducted with Natalie Ramos. Ramos was never shown a lineup, a photo array, or even a single image that was undisputedly of the defendant. Although Ramos was present when her best friend was shot, she told police that she did not know the shooter and she offered no description.
Well, she was shown the video surveillance. So she was shown that. So why was that not a identification procedure?
Your Honor, the cases that defendant relies on are distinguishable from this case because of 2 key reasons. First, in all of the cases defendant discusses, in none of them was the witness shown surveillance footage that was undisputedly of the crime, as it was in this case. The only image that the witnesses were presented with was an image that was undisputedly the shooter who was in the process of shooting the victim. And second, another crucial difference here is that in none of the cases defendant references was the image, in all of the cases defendant references, the image was undisputedly of the defendant. And in this case, defendant was certainly not willing to concede that this was him depicted on the surveillance video. He wasn't even willing to concede that it would have been possible to identify the shooter's face from that video. So although they viewed the surveillance footage, this was footage that actually depicted the crime, not a police acquired image of the defendant that was presented for the witness to pick out the shooter. And when Natalie Ramos was shown the identification footage before the surveillance footage before trial, the prosecutor explained to the court that Ramos, quote, recalled the incident. She described it to me. She stated that she knew and was familiar with Jamie DeJesus. And when she watched the video, she was familiar with the location and all of the major players in the video. That's on trial transcript page 290.
What about the argument as to the necessity for a Rodriguez hearing to determine her familiarity with the defendant?
Well, Your Honor, because this was not an identification procedure, no Rodriguez hearing was necessary. However,
so if a Wade hearing was not necessary, then a Rodriguez hearing would also not have been necessary. Is that
correct,
what you're
Your
arguing?
Honor. Correct, Your Honor. And in this case, notably, her acquaintance with defendant was explored on the record at trial. Defendant refers to a lot of these post-event, these sort of extracurricular facts that may have been influenced Natalie Ramos's final willingness to come forward. However, as the Supreme Court discussed in Perry versus New Hampshire, the fact that a defendant is on trial does not entitle the defendant to judicial inquiry into the reliability of an identification. What we're concerned about in a Wade or Rodriguez context is the suggestive or misleading police conduct that could taint an eyewitness's identification. And
so
here,
could you address, in the few minutes you have left, could you address the issue as to the defendant's sister, Ashanti Rodriguez?
Certainly, Your Honor. The defendant's sister, Ashanti Rodriguez, unlike Natalie Ramos, was not an eyewitness. She did not have an independent recollection of the shooting. She did not name defendant as the perpetrator. She was trying to identify the perpetrator on the video based on her prior familiarity with defendant. At the Rodriguez hearing, the detective had spoken to Ms. Rodriguez earlier that morning and confirmed the details about her acquaintance with defendant. They attended the same Bronx high school together. Rodriguez was 1 year older and they had friends in common. She was actually close with one of defendant's cousins. Defendant even had an affectionate nickname for her. He called her grandma because he would try to get her to come and hang out with him and his friends, and she would refuse to hang out with them. For several years after high school, they saw each other several times a year. They'd exchanged cell phone numbers and were Facebook friends. And on this record, the court correctly found that this was a long-standing relationship of many years, that Rodriguez and defendant were significantly more than acquaintances, and any identification
But
was
Ms. Rodriguez was called upon to offer an opinion as to whether or not the individual depicted in the video surveillance was in fact the defendant. Was that proper?
That's correct, Your Honor, and that was proper. And the court promptly charged the jury, gave them an instruction that her testimony was an opinion about the video that was being submitted for their consideration, and they, as the finders of fact, were free to accept or reject that. They were so instructed both during her testimony and again during the court's charge, that this was simply an opinion that was being offered that they were free to consider. And any error in permitting her to do so was harmless. The evidence against defendant was overwhelming. He raised neither the weight nor sufficiency of the evidence on appeal. The jury
Thank you, counsel.
Thank you, Your Honor.
Ms. Wolf, you have 2 minutes.
Thank you, Your Honors. Natalie Ramos was called to the prosecutor's office, shown a video, asked to identify the person on the video, as my client and then come into court and identified him for the jury on the video. The trial court relied on a Court of Appeals case, People versus Gee, to say that this was not an identification procedure because she was there. This court has never held that when someone is shown a surveillance video and prompted to make an identification based on that surveillance, how transformed into no identification procedure. And there's no court that holds this. This was an identification. Ms. Ramos was called in for the express purpose of testifying. In the context of preparing her testimony, my client, she went into court. This was the only testimony that the jury needed to hear again before they convicted my client. It was potent, powerful, emotional testimony, and it's what they needed to come back the next day and render a conviction verdict. And it is unquestionably an eyewitness identification based on this video, and it should not have been heard by the jury unless the court was certain that it was reliable. We don't know anything about how Ms. Ramos knew my client. We don't know whether she'd ever spoken to him, how she'd ever interacted with him, if at all. She doesn't know who his friends are. Who knows whether she knew him or not, or whether she backdated all the information with all of the post-event information in the 2 years of his prosecution. And for all these reasons, a new trial is required. Thank you, Your Honors.
Thank you very much, Counselor. Mr. Lawless, are you with us now? Do we have Mr. Lawless yet? No. Okay. Well, let's just skip over that 1 second, Counsel. Let me go to Abraham, and then if Mr. Lawless is not back, we'll come back to you. Okay.
Okay. Thank you, Your Honor.
Thank you. Abraham v. Dutch Broadway.
Good afternoon, Your Honor. Elon Wurtzel for the appellant. This is a relatively simple case. We had a defendant move for summary judgment, and on every issue that the defendant raised in their motion, the court rejected it. On the one issue, and the most important issue, the issue of constructive notice of a sidewalk, which was never raised by the defendant in their summary judgment, for some reason, the court granted their motion to dismiss without proof that there was any prior inspection by the defendant of the subject area. In fact, the defendant testified that for at least a 5-year period before the accident, had never been on the sidewalk where this accident occurred. So the defendant proof in terms of seeking summary judgment was completely deficient, did not make a prima facie showing. And even if it did, there is evidence from photographs of the condition of the sidewalk, and it's apparent from looking at the photographs that it's a condition that only could have occurred over a long period of time. Broken sidewalk, a differential in height of over, almost an inch, and it's not something that occurred overnight. So even if the defendant made a prima facie showing, there were genuine issues of fact that should have resulted in a denial of the motion. I also want to just raise, Your Honors, in their brief, the defendant raised several issues that had never been raised in the motion below, relating to the accident could never have happened, my client's health condition, and raising initial concerning trivial defect. None of those issues were ever raised below. They're raised for the first time on this appeal in their brief and shouldn't be considered by the court. I rely on the arguments made in our brief and reply brief. Thank you very much.
Thank you. Respondent?
May it please the court, this is Sean O'Shaughnessy for defendant Sweeney on behalf of respondent Dutch Broadway, excuse me. I disagree wholeheartedly with plaintiff's contention in the case or appellant's contention in the case. You have an out of possession landowner who is Dutch Broadway in the matter, and in its initial proffer, Dutch Broadway put forth 2 deposition transcripts of the plaintiff as well as an affidavit from their principal, Mr. Dalto. Within Mr. Dalto's affidavit, he clearly states that there's been no prior complaints, no accidents related to the subject area. Now, counsel would like this court to believe that this is a multifaceted trip and fall. What we have here is an appellant who's walking out of a liquor store towards a convenience store on a sidewalk. He indicates he has no problem seeing the entire way towards the store. As he's walking towards the store, he walks past the subject areas, no issues whatsoever. stops to take a look inside of that convenience store for just a few seconds, realizes he does not see the person there who he wanted to see, turns to his immediate left, and for some reason, we don't know why, his right foot makes contact with something. It's only after the fact, after he's fallen, that he looks back and sees some carpeting in the area, one of which is on the ground, two of which are still standing.
As to the defect, Counselor, as to the alleged defect, did you present anything as to whether or not you had constructive notice of any defect?
We did. The affidavit of Mr. Dalto was placed in the initial motion for summary judgment. Within that affidavit, it clearly states that there are no defects with respect to carpeting or mats, because that's the primary area where, when the appellant looks to his left and starts back towards his car and back towards the liquor store, that's what his right foot makes initial contact with. It's only then that he stumbles towards the concrete obstruction or sidewalk imperfection that he only sees after the fact. So he walks through the area, doesn't see anything wrong with the area, has no issue seeing. It's only after the fact that he's finding these defects.
So do we have anything against as to when the sidewalk was last inspected?
Mr. Dalto does say at his deposition that he does perform routine checks of the area. He does drive through the property routinely 2 or 3 times. He was last at the subject site about 2 weeks before the accident. He was not specifically on the sidewalk at issue 2 weeks before, but he was on the property. Again, he is an out of possession landlord, so he's not required to have a HUD or have some sort of constant presence on the property.
But not constant presence, but I mean, wasn't it a little vague in terms of exactly when he quote unquote inspected the sidewalk, or when he visited the shopping center and therefore saw the sidewalk?
Well, he does say that he's at the property 2 weeks before, a week or two before the subject accident. That's very clear. It is less clear whether he actually walked the sidewalk in front of the area. This is about 200 square feet of sidewalk area in front of the mall. So again, I don't believe he has an obligation to walk the premises every time he's there, but he is on the property 1 to 2 weeks. Finally, the photographs that counsel referred to clearly show that.
I'm sorry, Justice Owen, did you have a question?
Yeah, counsel, I'm looking at his EBT. You may be correct about he's an out of possession landlord, but the person that was testifying, Mr. Dalto, said that he does go, he drives around, he looks at the area, he's also inspects the sidewalks for cracks and all that. And then when he was asked pointedly at page 30 on his EBT, do you recall when the last time you walked in front on the sidewalk or front of the convenience store prior to December 2016? His answer was, I don't recall.
That's correct, Your Honor.
I mean, so, he starts off, in a sense, you go down the path in terms of what you're doing, like visually inspecting, and then he just doesn't remember when was the last time he did it.
Correct.
I mean, isn't that a factual issue then?
Well, I would disagree with that only because he does say very clearly, and counsel asked him the last time he's at the property before, he does say the week or two before. He's not specific. He doesn't specifically say.
Yeah, I know that. He said in the deposition, he drives around in his car. He looks out the window. He looks out the window.
Correct. The final point I'd like to make is the photographs that everybody keeps referring to. The photographs clearly show from the directionality, and I don't think you need to be an expert to figure out that you can't trip and fall when you're coming from a higher location to a lower location. And that's exactly what we have here with the sidewalk obstruction, or the sidewalk imperfection, as the plaintiff himself calls it. You're walking from a higher area to a lower area. Can't trip and fall over that. He's simply stumbling as a result of his contact with these carpets that my client didn't put there. That's very clear. My client had no notice of the carpet that was put there, and the tenants are the ones that are responsible for clearing trash and debris from the area. So I would ask that the lower court decision be upheld for all purposes. Thank
Counsel, this is Justice Kennedy, and I'd just like to go back because the photographs certainly depict a raised sidewalk, and Mr. Dalto is silent as to whether or not he inspected the sidewalk for any height differential. There's no evidence.
You're wrong. I'll agree with you that the sidewalk does depict an approximate 1 inch height differential between slabs. However, the directionality, when you look at it, there's no way Mr. Abraham could have tripped and fallen from a higher sidewalk flag to a lower sidewalk flag. It's physically impossible. You don't need to be an expert to figure that out. He's not coming from the other direction where your foot would catch the sidewalk flag and then he would trip forward. He's simply stumbling from the initial contact with these carpets. So this is really a carpet case. It's not a sidewalk case. And in the end, the plaintiff essentially falls, doesn't know why he fell. He did have some prior balance issues in the week or two before the accident. But he looks back and then he realizes, what did I fall upon? And that's when he sees carpet that it's rolled up about 2 feet height, 2 feet tall. So again, it's our position that the underlying decision was 100% correct. Thank you.
Thank you. Swartzel, anything further from you? No? You're muted. Nothing further?
No, Your Honors, we rely on our briefs. Thank you.
Thank you very much. We'll go back to Medina versus NYCHA.
Okay, good afternoon, Your Honors. I don't know if Mr. Lawless is here or not. It's okay if I begin?
Yes, please.
Okay, thank you. I'll try to be brief here. So the trial court's order was short, and it looks like they denied plaintiff's motion for summary judgment for 2 reasons. The first one is, at least in the court's words, plaintiff had described this sound she heard from the cabinet as being comparable to some kind of rodent. The problem with that is that plaintiff never told the housing authority that I hear a sound and I believe it's a rodent. What she said was that there's a strange sound coming from my cabinet, which had just been installed, and the housing authority said, okay, we will come to inspect it. This process repeated itself 3, if not 4 more times.
Counsel, this is Judge Owen. Counsel, this is Judge Owen. You represent, just so I'm clear, you represent the plaintiff or the defendant?
The plaintiff.
Okay, you represent the plaintiff. Okay, so.
Correct.
Because the question I had, and this was something I was going to ask the housing authority, but he's not here. Your client, though, after it was installed, did tell the installer, hey, I'm hearing something. She, according to her testimony, she ran out and got him to come back and said, I hear something, right? And he says, I don't hear anything. She did.
Basically, immediately after the cabinet had been put up, she started hearing a noise. And hopefully we can agree that cabinets don't normally make noises, whether they're creaking or however she wanted to describe them. So she flagged the worker down. I think it was by the elevator. He came in, and according to her, he basically did a cursory look at it. He said, I don't hear anything. It's fine. And he left.
Here's the next point. Here's the next point I want to make. This installer is not the original. It's not the first installer, right? There was a first installer who came and said, whose testimony was, I can't put the cabinets up because the wall is not in proper condition for me to put the cabinets up. It's got to be plastered and then re-anchored. Correct? That's the first install, right? But we don't have any, right, and we don't. And he's not the guy that came back to put it in. Some other guy came back to put it in, right?
Correct. The witness who testified for the housing authority is the one who removed the first cabinet. He had no knowledge of anything that was done after. He did not know if it was replastered. Even looking at the photographs, he said he didn't know if any grounds had been put in. And that's the problem here, that the cabinet didn't have the proper support. The carpenter who supposedly installed the new cabinet never testified. So what you said is essentially spot on. And even though the initial installer supposedly came immediately after plaintiff flagged him down, she continued to hear this noise for months. She registered at least a handful of complaints. The housing authority said somebody would come. No one did, and essentially what happened was her complaints fell on deaf ears. A few months later, the cabinet completely detaches from the wall. And based on that, I don't see how the housing authority can claim that they lacked notice.
Well,
the argument about vermin.
Wasn't she the only one who was hearing the noises? Wasn't there something in the record that her son, no one else in the apartment heard the noises as well?
Well, at the time, the only other person living with her was her son, who at the time of the accident was either 12 or 13. I believe there was essentially one line of testimony.
Oh, that explains everything. Teenagers never hear anything. Teenagers don't hear anything.
Yes, to support that,
what
was that son doing?
Blowing up, and they were like, "Huh? I don't hear a thing."
I'll tell you what.
I recognize. I know the housing authority obviously is not here for whatever reason, but did they put in anything as to why, other than the fact that their own people said that there was nothing wrong with the installation? Did they put in anything as to the initial the individual who initially took down the cabinet, stating that he was unable to, install a new cabinet because of the fact that the wall had been compromised? Did they put in anything that went to that issue?
Well, it's actually included as part of their own work order. I believe it's 388 of the record, where he wrote down himself. I'm going to say this as closely as to what the work order said as possible, that he removed the old cabinet. It needs new plaster. There are no browns. Wall is not suitable for hanging. That is the last instance of him having any kind of personal knowledge about this. And then when he was asked, do you have any idea what was actually done after this? He said, no, even looking at the photographs. Could you tell from these if there are any browns in the wall which are required to support it? He said, no.
Justice Scarpula, did you have a question?
I wanted to ask, wouldn't there have been a ticket or some kind of subsequent work order if work would have been done?
You are correct, Your Honor. So basically, these carpenters, they were within a certain group. Right. They were all within what was called the skilled trades department at the housing authority. And the housing authority produced these work orders for when the cabinet was removed and when the cabinet was installed. They're silent as to what happened in between that time. And if you actually read them, you could look, it's page 401 of the record. There's a timeline of what was done. And all we have is July 2014. That's where the witness said, I removed the cabinets, the wall wasn't suitable to install a new one. You fast forward to August of 2014, where supposedly this other carpenter simply put up a new cabinet. And nowhere is it noted that he did what he had to do to make sure it was safe.
And one would assume that there would be a record of that if someone actually in between those two periods of times actually came in and fixed the wall.
Exactly. We had demanded it, and this was the housing authority's exchange. So you're correct. Yes.
Thank you, Counselor. Any other questions? Thank you very much.
Thank you.
Next case is Bacchus versus Bronx Lebanon Hospital. Bacchus?
Jason Turkin here for the respondents, Your Honor.
You may proceed.
Good afternoon, Your Honors. I apologize. I was on mute. This is Seth Kornfeld. I represent the appellant.
Thank you.
Thank you. May it please the court. Thank you. My name is Seth Kornfeld on behalf of the estate of B.B. Bacchus. In this action, this appeal was taken based upon a Bronx County Supreme Court decision that granted partial summary judgment to the defendant, Bronx Lebanon Hospital, and dismissed the 5th and 7th causes of action of pecuniary loss and wrongful death. The lower court erred in partially granting the defendant's motion for summary judgment. The plaintiff respectfully requests this court reverse the lower court and deny and reinstate these causes of action in the Supreme Court.
So the basis for the granting of summary judgment was because of the preclusion order, which specifically stated that you were to provide the enumerated authorizations by a certain date. If you failed to do so, you would be precluded, and you failed to do so.
So that's correct that there was a preclusion order. However, in terms of the timing of the preclusion order and the change of counsel is the important point here. So the preclusion order was issued Honor, about March.
Counsel, I got a really basic question. Do you have the source of income information that the defendants were looking for to support these two causes of action? That's the bottom line. You either have it or you don't. You don't have it, you can't go forward with these two causes of action. So putting aside all the delays and whatever the defendants are arguing that you didn't comply with this, do you have these documents? Do you have the source of income to support these two causes of action? That's what I'm most interested in. Well, your pause is too pregnant for me to feel comfortable about.
Your Honor, at this point, I don't have that in our possession. But again, I think the issue is that the preclusion order and the timing is the main, point of the idea that we
I'm
had.
not with you. You don't even have to argue with me about that. Okay, I agree. Timing, things happen. We all have things going on. But if you're standing in front of me right now and says, Judge, I have every single document they're looking for, but I'm not getting that. I'm getting instead the argument that we have a timing issue and that the preclusion order should have gone through. It's much more about the same thing, because if I were to agree with you and send this back, reverse Supreme Court and send it back, you're still going to be saying, I need more time. I need more time. We were going around in circles. I'm just trying to, if I were to agree with you and send it back, you got to be able to produce the documents. You got to produce the source of incomes to support these two causes of action. If you don't have it, why am I putting the defendant in that situation, in that kind of scenario? That doesn't, I'm not hearing what I want to hear. So, okay, I got my answer.
So I understand your perspective on it. I think, in terms of the timing, I think we've kind of already discussed it. In terms of one of the other issues was the reason that the reason that the preclusion order was enforced was that the claim that the plaintiff didn't provide any collateral source authorizations, and prior to my office assuming representation of our client, in a letter dated January 31st, 2018, an authorization for Medicaid was provided on January 26th, and that letter states that the only collateral source for the decedent was Medicaid. In addition, I know we provided Social Security authorizations as well.
Do you know what your client, the decedent, did? I mean, was he working at the time?
It's actually a she. This is
Sorry,
on behalf of that's okay. At the time, she wasn't working, but or at the time, yes, at the time she wasn't working.
All right, thank you.
And
So I'm sorry, Counselor. Again,
Yeah.
Your argument is that there was an abuse of discretion by the court following the terms of the preclusion order. Is that what your argument is?
Well, my issue is the abuse of discretion was based on the timing and the timing of the preclusion order in relationship to the change of attorneys from the prior counsel to us, where the preclusion order was in.
Judge Scarpullo, let me just ask you, at the time the preclusion order was issued, had you put forward, I mean, the date had already passed, but the preclusion order wasn't entered on that date. Subsequently, the preclusion order is issued. At that period of time, had you even put forth the medical authorizations? I'm sorry, the authorizations for the records?
So at the time the preclusion order was entered, this office was not.
I just want to know whether anybody, prior counsel, anyone, had done what they were required to do, even though the date had passed. Had anyone sent those authorizations out?
So as soon as our office as soon as our office recognized it, obviously, as soon as we assumed representation and recognized the delay, we did. We immediately sent out the authorization.
That's really not my question. My question is, a preclusion order, a conditional preclusion order is issued. You have a certain period of time. You don't do it.
Correct.
Then the order is self-executing and supposed to go in. But there's even more period of time between when you don't do it and when the judge actually signs the order. Did anyone during that period of time put in the authorization?
So
And
yes.
she was represented by counsel during that whole period. Maybe not you, but she was represented by counsel, right?
Yes, that's correct.
Okay. All right, thank you.
So, counsel, you have time on rebuttal, I believe. No, you don't. I'm sorry, you don't.
No.
Thank you.
Thank you for all the following reasons. Defendant's motion should be denied. Reversed.
Yes, respondent.
Good afternoon, Your Honors. So I just have a few points to make on what Judge Oing was asking about. You know, what we were trying to prove from the very beginning, because we thought it was obvious when we started reading the case, was that there would never be any proof of pecuniary loss, loss of income, wrongful death damages. And so we were just trying over the course of about a year and a half to get the authorizations, to get the records, so at least we could make those points pretty quickly in the case and get those out of the way. But plaintiff's counsel made it impossible because they weren't providing the information. We never made our motion about a Medicaid authorization. Plaintiff's counsel argued below, or at least argues now, that they gave us a Medicaid authorization in the January before all these conferences started. But Medicaid, as everyone understands, isn't really a collateral source for the purpose of showing wrongful death damages, because Medicaid covers medical expenses. Right. And we didn't include Medicaid in our motion. It wasn't ever part of those orders or part of our motion. It wasn't going to be helpful to us. In addition, the Medicaid authorization, as plaintiff's counsel pointed out, came under a letter stating this was the only collateral source there ever was. But plaintiff's counsel knows that in the record on page 277 is a letter plaintiff's counsel ultimately provided us from Social Security, written to the decedent, explaining at some point that they're adjusting her Social Security benefits. So that is evidence that there's Social Security. But we just don't know what it was, and we never got an authorization for it. So at some point, it just became that we said, okay, we're never going to be able to disprove these allegations with the evidence. And now we're going to have to make an issue about the fact that we can't get the evidence. And the court ultimately, after several hearings on this, issued the order of preclusion. And the date came and went. They didn't provide the records. It was really that simple. And then when we moved, they didn't oppose on time either. So Judge Capella ruled that he wasn't going to accept the opposition because they didn't oppose on time, and they didn't offer an explanation in the opposition why they didn't oppose on time, and they didn't offer an explanation in the opposition why they hadn't ever provided any of those materials. And now on the appeal in their brief, they've offered, I'm going to say, sort of excuses about an attorney who worked for them, but they never threw that attorney under the bus in their opposition papers to the motion, to the underlying motion. And this current firm wrote the opposition to that motion. It wasn't the prior attorney.
Well, didn't they claim law? Did they not claim law office failure to the motion court?
No, they did not. It's not.
They did not include that.
They did not. But they include it now. But it's not the sort of, when we all watch the news a lot, and there are excuses and apologies, and then there are pseudo ones. And so what they're arguing now is they're kind of arguing law office failure only on the appeal, didn't argue it below. But in doing that, they're really throwing a former attorney under the bus. They're not really saying it's our law office failure. It was just that terrible attorney we employed, which, all I'll say about that is it wasn't in the underlying papers. And
well, counsel, this is Judge Oing. My concern is, I don't know if you heard, my concern is that if I would agree with the appellant, you still wouldn't be getting what you want, because that's what I asked him. I said, do you have the source, the collateral source information that the defendants need to defend the case? Because it's lost income, right? And it's wrongful death. I didn't get the answer I was hoping to get, because I'm trying to get the information for you.
And we suspected, Your Honor, that there would really never be anything or almost nothing to get, but we could never get to the point where we could actually affirmatively show that, because we couldn't collect the evidence of it, because they didn't want to provide us with the ability to collect the evidence of it.
Thank you,
Justice Capella lost his patience for that. Thank you,
Your
Your
time
Honor.
is up. Thank you very much.
Thank you.
Next matter is TKS Realty versus 391 Broadway. TKS Realty versus 391 Broadway.
Joseph Nyman for the respondent, Your Honor.
Where's my appellant?
He might show up as a cat.
You like that, don't you? Okay, let me go to Aaron Law, and then we'll come back, Mr. Nyman. Sorry about that. Aaron Law versus New York City Department of Education.
Yes, good afternoon, Your Honors. Joseph Aaron for petitioner.
Yep, there you go.
May I reserve 2 minutes for rebuttal?
Sure.
Thank you very much.
You may proceed.
Okay, thank you. If it pleases the court. Okay, so this case relates to a FOIL request, and it's really about two things. One is the requirement that a request is reasonably described, and the second part is the value of the Barnello affidavit, which is the affidavit that was submitted by the Department of Education.
Now, Counsel, I have a question. Sure. So this whole FOIL request is more of a, and I'm trying to phrase this correctly. Your FOIL request is to demonstrate, or at least for you to prove, or at least get out there that the DOE's process or protocols are wrong, or skewed against producing documents, right? It's not as if you're looking for a particular document support a cause of action or a claim that your clients have, but you just generally, because you represent clients and you make FOIL requests for clients, and you want all this information to show that DOE is what they have in place is all skewed against turning documents over, correct?
So I think their practices are suspect, but it is correct that, I represent various media companies that have a specific interest in substantial equivalency and other education stuff, and do a lot of FOILs with the Department of Education. So a result of those, we're coming back needle in a haystack. So I was.
But that's what I want to get at. Needle in a haystack. It's more like a fishing expedition that you're doing, because it's so broad. You don't have a sort of a direct interest or a direct issue that you're looking at. So what you're looking at is you're doing it going back 5 years, and you want to prove or at least demonstrate that the practices are skewed against people looking for information, right? I mean, so that's kind of broad.
Well, Your Honor, I appreciate the question, but I totally disagree with the premise, because the Court of Appeals is clear on multiple occasions that one making a FOIL request need not give any type of reason or have a rationale or a justification. In other words, the question here purely is whether or not what I asked for was reasonably described, which I'd hope to have the opportunity to get into the various items. But it is.
Counsel, I'd like to go back to the affidavit, because I know that you're challenging the affidavit of the records access officer. Yeah. My question to you is, what documents did you introduce to refute what was set forth? Because it was very detailed in that affidavit about the difficulty of identifying and producing the documents. What did you produce in opposition?
So let me say two things. I don't believe I have to produce anything in opposition, and I'll tell you why. First of all, I don't have an opportunity because we're bound by what was in the administrative record, and the last part was a determination on my appeal. But the case law is very clear that they have the burden to show that whatever it is, here they're saying they can't get what I want to get. Now, what this case centers on is items 2 through 5 are literally binary. They're a keyword. They're looking for a search. So the question comes down to, is an IT question based on the software that the DOE uses. Could they retrieve that with programming as opposed to new software? Now, this court, the First Department in Bloomberg, said very clearly, and it was actually a statutory modification to FOIL, that if the request just needs programming to retrieve what's in the database, the agency is obligated to do that. Now, the affidavit that they submitted, it wasn't from an IT guy, it was from an attorney. He doesn't even say I spoke to an IT guy. He says, based on how I use the program.
Yeah, but counsel,
I'm not sure if that's accurate, counsel, because I mean, he really laid forth his authority and his experience.
No, everything was based on his usage of the program. And he says, I think twice on the thing, this is what I know how to do, and this is what I don't know how to do. Nowhere in there is that he spoke to an IT person. But
you're making the determination that it requires a specific quote unquote IT person. This individual, although he's an attorney, he states that he has the expertise and he has the information technology expertise to find these documents. So you're the one who's stating that you need an IT person.
Yes,
there's nothing in any of the cases or anything that says that it has to be a quote unquote IT person.
So I disagree, because what he says is this is what I do for my routine usage. He doesn't anywhere attest to the limits of the program.
Counsel, just not to cut you off, but this Judge Oring. It's like doing a Westlaw search. You don't have to be an IT person to do a Westlaw search. I mean, you type in your keywords and the things come up in Westlaw. We all do it. Lawyers do it all the time. All right. Yeah, so it's not a specific, especially what you're saying, that you have to type in keywords. Anybody can do that. But here's the other question. Assuming that I agree with you, that all this stuff could be found.
I don't know what that is.
Simply by typing in the keywords, right? We're dealing with, unlike the Bloomberg case.
Hold on. That's administrative, right?
Okay, excuse me. I think Mr. Zhu, if you could please mute.
So unlike the private Bloomberg, private companies and everything, we're dealing with the DOE. DOE is a special animal in the sense that they have information about students and all the other things that are confidential. And under law, they cannot disclose it. So that you give them all these key words and they start popping up. You're going back 5 years. That's a lot of documents. They got to be sure that they got to redact out all personal information about students.
Okay, so Your Honor, you made two separate points. I'd like to please address both. Okay. In terms of, it's not like a search on Westlaw. The statute says that they have to do programming. That's what I'm asking.
So, counsel, I think you should get to the second issue. Okay. I don't think that's your best argument.
The second issue in terms of the protected information, like they allege FERPA, so there's two issues with that. First of all, this database is exclusive to FOIL requests and responses. So there's no evidence that there's anything in that would be protected by FERPA, because presumably any request that's made under FOIL in of itself is a public record. FERPA is a very narrow, and it protects education records. That's the language in the federal statute. So I don't think anybody's really believes, I mean, it was a throw in the kitchen sink argument, but nobody really believes that this database is covered by FERPA. And if that's an argument that they want to make, that should also go to a hearing. So that's my response to that. But just to circle back with the Bloomberg, it's not just the Bloomberg case. It's also in the statute at 89.3 was modified in 2009. Their obligation goes beyond searching. It's in between developing new software and a simple keyword search. It requires a coder.
Counsel, this is Judge Scarpula. Other than your saying it's so, did you put in any expert affidavits or fact affidavits from former DOE people who know DOE records? For example, you dispute that the DOE records have any FERPA-covered information. Well, good for you, but did you put in anybody who actually knows whether that's true to dispute the DOE's affidavits that say it does? And two, did you put in an affidavit from an IT person who said you could do this search this guy doesn't know what he's talking about. You could do this search with no problem. Did you do either one of those things?
So first of all, the affidavit.
I just want to ask you whether you did, and then I'm
Your Honor, I did not. May I explain why?
Yes, of course.
I don't have
access. I just want to make sure that we're both agreed that you didn't put any of that in.
We're on the same page. I did not do any of those things because I don't have access. What I'm seeking here at the very least is a hearing that would give me the access to question someone from the Department of Education.
How do you, but you're making, I don't understand, Counselor. You're stating you don't have access, but you just made these statements. So why could you not find an expert who would be able to back you up in these statements? You said you need an IT person. You said it's the database. You said that that it does not include confidential information. So this must be based upon something, because you wouldn't just be throwing out these arguments without some basis for making these arguments. So why don't you have an expert who would be able to support you in these statements?
Well, the lack of confidential and privileged information comes from the Barnello affidavit, because that in of itself says that this database is only FOIL records. It's nothing else. So these are not education records. They're FOIL records. So that's my answer to that. But my answer to the other one is it's their burden. It's not my burden. If your honors finds that affidavit is adequate, I'm finished. The question is whether or not that affidavit is adequate to show that the software they have can't be programmed to retrieve the information I'm asking. So I acknowledge that. If this court finds that Mr. Barnello knows the limits of the IT system and made it clear in the report, so then I don't have a leg to stand on.
Counsel, then let's just do that, because that, as we know in practicing law, you always assume that you're going to be up against the wall and you got to come up with your own. You can't always say, or at least rely on the fact that they didn't meet their burden. Always assume that they met their burden. What do I got that's going to be able to undermine the fact that they've met their prima facie burden? And so
on
far, I
that
haven't
note,
heard anything.
we will move to the respondents. Thank you, Counselor. You have rebuttal time, Counselor. Respondents?
Thank you. May it please the court, Jeremy Schrader for respondent. What felt like at the beginning of the briefing of this case to be a big challenge to the legal interpretation of reasonably described in FOIL has really turned through the appellant's reply brief and through this argument into just a factual determination over whether the affidavit sufficiently showed that it was going to take too much effort to find this document. And I think the court has this exactly right. This is a very detailed affidavit by the DOE, by somebody who has knowledge of how these things work. These are the kind of affidavits which are always accepted as being from somebody with knowledge. You can look at the Reclaim the Records case that I cite from the 3rd Department from just last year, where somebody who I believe was a FOIL person with the exact same title as Mr. Barnell here, his affidavit was accepted. There's not really a lot of questions that this person is qualified to give this information. There's a question that my colleague has raised that he now says he wants a hearing. Now, of course, that was never asked for below. And I don't think really the way to go about this is to say on appeal for the first time, well, I really should get something that I never asked for below, never gave Supreme Court the chance to even consider. So I don't think that that's something that really is appropriate now. And of course, he did have every chance to challenge the affidavit. It is our burden. We, I think, amply met our burden. And at that point, he has to do something to try to challenge it, as this court has recognized. I think that's pretty obvious. This isn't really, I'll address the FERPA issue too. I don't think FERPA really matters here that much. We're talking about whether there's it would be unreasonable amount of effort to find these documents. To the extent you want to think about FERPA, I just want to say, he did not ask just for FOIL records. He asked for all records in the case file related to FOIL requests. This is the Department of Education. One can naturally expect that there are going to be many education records in the entire case file related to FOIL requests. So of course, FERPA is going to apply here. Again, it's pretty irrelevant. It was certainly irrelevant to Supreme Court's decision. I think it's irrelevant to what this case has to decide. Really, what is put in front of this case, of this court, is was the Department of Education's determination that it would take an unreasonable amount of effort to find these documents because of the nature of the request, because of the way their indexing system worked, and how it was proven that this was not reasonably described. Certainly, a different request might be reasonably described and might get a different result. But we're talking about this case. We're talking about the affidavit. I've gone through, and I don't really think it's really an issue anymore. I've gone through the legislative history of this law. I've explained in our brief the connection to the federal law. I think it's very clear that the Court of Appeals, this court in Asian American, is the precedent that I think really drives this court's decision, that reasonably described is the right way to look at this. But again, it feels to me as if those issues those legal questions aren't even really being raised anymore. And now we're just talking about the adequacy of the affidavit, which is essentially a factual question that I'm not sure this court can really say, looking at this record, to say, well, the Supreme Court really just got that wrong. That's what Supreme Court looked at. It made a decision. I think it was absolutely the correct decision, particularly when you see that there was nothing, there's nothing put in by my colleague other than he says, I don't believe it. I mean, that is his argument. I don't believe them. And, with that, I don't think there's much more to say unless the court has any questions.
Any questions? Thank you very much, Counselor. Yes, Mr. Aaron?
I'd just like to make 2 points. One is, should this court find, that the Supreme Court was right, it would literally be the first appellate court that made a decision on burden without the respondent demonstrating how many hours it would take to fulfill the request. There is literally, I don't believe, any other appellate case law where they upheld the denial of record without an enumeration of the time that would be involved to produce the records. There's no time span here of what the respondent shows they would have to do to produce the records. In the statute, I
thought they estimated that it would take an employee about 900 hours.
Okay, I don't see that. I was looking. They say the amount of folders, but I didn't see.
They say 5,400 folders covering requests, and for 5 years, tens of thousands of files. Rao estimated that this would, your adversary mentioned, was that you're now requesting a hearing, and I did hear that during your argument. Did you request any type of a hearing before the motion court, or is there anything which would allow us to direct a hearing at this point in time?
Well, I didn't request it in front of the motion court. I think what would allow it is what this court did in Bloomberg. I think what the Second Department did in Wisłowski versus Vanderhoff in 2012, which was the same thing, that they felt that there wasn't an adequate record on that. I think the same thing that the Jewish Press Court did 2 months ago in the Second Department to set it back down for a hearing on burden after 2 appeals. And I also think that item number 6, which we didn't discuss, is not electronic records. And there's absolutely no evidence in the record for item number 6 in terms of what has to be done to retrieve it. Item number 6 was for other affidavits where the DOE felt that records were not reasonably described. And there could be—
Mr. Aaron, this is Justice Kennedy. I'm not sure how Jewish Press applies, because in that case, the respondent conceded that it could locate the documents. We don't have that here. They identified their documents, and they conceded that they could locate the documents. We don't have any such, excuse me, sir, I'm still speaking. We don't have any such circumstance here.
There was a second appeal in that case that Mr. Schwader was actually the appellant, and it was sent back down to assess the exact burden in terms of timing and what has to be done to call the documents that were requested.
No, I understand, but also what I just said, there's no concession about finding the documents or that they can be located. We don't have that here.
Well, correct, but by number 6, we don't have anything here. It doesn't speak to request number 6, meaning in request number 6, I'm asking for records that are presumably in paper form. Mr. Barnello's affidavit doesn't speak to those records because they're not in the FOIL database. So there definitely seems to be an insufficient record on that one. In terms of the other ones, there's also a difference between 2 and 5, which are literally key search words, and number 1. So there's really 3 different types of records in terms of what has to be done for a search. So to broadly paint them all with the same brush and say that they don't have to do any of these three because of this Barnello affidavit that gives very little information, if any, in terms of timing, what's involved, I think, would not be the appropriate.
Thank you. Any additional questions? Thank you very much, Counselor. We are going to go back now to TKS. TKS Realty versus 391 Broadway.
May I please the court? This is Ren Daniel for the appellant. Sorry.
Yes. Appellant, please proceed.
This is Ren Daniel for the appellant. May I please the court? Good afternoon.
Yes, please proceed. You have 7 minutes.
Okay, thank you, Your Honor. I would like to discuss about 2 points in my brief because I think that the brief speaks to itself. I would like to discuss, the first point that I would like to discuss is the consideration issue. As we know, consideration must support all contracts. In the trial court decision, it was decided that the actual investment of the $100,000 was the consideration for the two defendants, Itzhaki and Busidan. This was actually in contradiction to the plaintiff respondent position that the $2.5 million that was shown in page 55 of the record, which is actually the Schedule 1 of the operating agreement that describes the members' capital as of the execution date, was considered as the consideration. Our position, in fact, that it's neither one of them. Schedule 1 of the operating agreement states specifically that the amounts that are shown in these exhibits are represent the amount invested by this investor and is not at the dollar amount. The amount indicates the equity stake that they hold due to their role in the LLC. Nowhere in this schedule says that this is the amount that actually anyone received for that. I want to discuss the history of this project. This project commenced in December 2012, where Busidan, Itzhaki, and other investors purchased this property for $8.5 million in the intention to redevelop this property to a condominium building. The plaintiff came into this investment, which was a closed investment, only fair to family and friends, and invested $100,000 in March 2013.
If we could discuss the option clause, because the argument was made that the option clause is unenforceable because its terms are ambiguous. Could you address that issue?
Yes, of course. I think that the brief speaks to himself, but there is a mix because of the way the agreement itself was drafted by Mr. Abrams, which was the agent of the plaintiff. My clients never seen the plaintiff itself, only after a year of this investment. There's ambiguity in the sense that Section 8.2 of the operation agreement says that the buyout option will be personally guaranteed by Erez Itzhaki and Gil Busidan. There's nowhere in this agreement where they say that they will guarantee this investment. There's nowhere in the operating agreement that says what's the consideration that they receive for this investment. There's also ambiguity about the term. As you know, put option is a put option and needs to be specific with the term. There's no term to this option, and it's also not really clear what will be the consideration for the put. When you exercise the put option, you're supposed to receive an asset in return. So that was our argument about the ambiguity. That's for this point.
And your argument as to why, you also have an argument in terms of the interest and the calculation of interest. Is that correct?
Yes, correct. If you look at the plain language of the operating agreement, the language says that the return shall be calculated on per annum basis, starting from the day when the member first paid their membership interest to the day which they pay off. This is simply the plain language of the agreement. And you know, it's pretty custom in the area, in the field, that if there's no any additional language, then simple. It's not compounded. Whether the party's intention or the meeting of the mind was that the annual interest will be compounded, then the word compounded will be embedded in the language. That's why we think that the trial court erred in its decision, at least with regards to the interest. I think it's simply demonstrated in the language of the agreement.
Any questions? No? Thank you. Mr. Neiman?
Thank you, Your Honor.
I would like to, I'm sorry, Your Honor. I think I have more time. I would like to discuss another point.
You have 1 minute. I'm sorry. I do apologize. You do have
Okay. Okay. I'm sorry, Your Honor.
That's okay.
I'll try to squeeze it. We also want to discuss about the fact that we have not been given the opportunity to perform discovery. This case was litigated mostly during the pandemic. The offices of my clients were closed. We had no access to emails and nowhere. As you know, a motion for summary judgment is premature when the non-moving party has not been given reasonable time and opportunity to conduct disclosure related to the evidence. This was a closed investment. There was a lot of communication between a guy that worked for my clients and brought one of his family members. There's also, I also added in my reply an email, a language from the email of December 8, 2016, which was never produced to this case. First of all, because of the pandemic and because we had no chance to conduct a proper discovery and produce proper evidence and comprehensive evidence to the court, to the trial court. I'm sorry, Your Honor, I think.
No, that's quite all right. Thank you.
Thank
now, Mr. Neiman, thank you. Thank you for waiting, Mr. Neiman.
Thank you, Your Honor. May it please the court. Initially, I'll first deal with the interest calculation, and I will admit that I left out of my brief, which I should have put in there, the fact that this was not brought up down below. The record has the memorandum of law submitted by the defendant. It has the affidavit in opposition, and it makes no mention of the fact that our calculation of interest is somehow incorrect or improper. This is something he brought up totally new, which unfortunately there's been a habit here. And one of the reasons I requested oral argument and what Mr. Daniel just mentioned concerning COVID and concerning his client's office being closed during this whole litigation. And I would respectfully refer the court to page 15 of Mr. Daniel's brief, or of the appellant's brief, where he says, the litigation commenced on September 23rd, 2020, and ended with a decision and order of the trial court on July 7th, 2020. Unfortunately, defendant appellants had no access to their records due to the pandemic. The matter did not start on September 23rd, 2020. It started in 2019. The motion for summary judgment was filed on February 27th, 2020. The response was on March 23rd, 2020. That was 3 days after New York first shut down regarding the COVID pandemic. The whole time during this litigation, there was access. There was no pandemic issue, and for him to come in now for the first time and raise a COVID issue, and that's the only reason I asked for oral argument, is the fact that I know the courts are very sensitive to COVID issues that have been going on the last 14 months. This was not a COVID issue. There was no, he had no, I don't know how a case starts in September of 2020 and ends in July 2020, which is what he said, but that's not the case. It's September 2019, which is when it started, when the action was commenced, And the motion was filed in February of 2020, and the reply papers and his papers were March 23rd. On the issue of the interest calculation, it was not brought up, it was not mentioned, and I think Judge Enghorn got it right, because in two different spaces, first it says 10% per annum, and then it says calculated annually. If you're going to calculate something annually, the only reason you would do would be because it's that you compounded annually. If it said calculated monthly, it would be compounded monthly. It didn't. It said calculated annually. And it also said per annum in another space.
Judge Scarpullo, normally in a commercial document, if you intend to have interest compound, you say compound. It's the exact opposite to what you're saying to me. If you want to compound, the sort of the default standby is simple interest. And if you want it to compound, you put in the document, compound the interest. Is there any place in this document that says compound the interest?
It says calculated annually, Your Honor. It doesn't say compound.
Right. So that would normally, in a normal commercial setting, that would mean simple interest, not compound interest.
I guess, if that's what you're saying.
I don't know, maybe I looked at I'm sure you looked at a bunch of commercial documents, as have I, and we've both done commercial litigation. So I think unless you say compound, it means simple.
It would, but there was no, again, my understanding of words in a contract are supposed to give a meaning when as opposed to not giving them meaning. There was no reason to put calculated annually if in fact you've already got in another section saying it's per annum. Once you've got per annum, that's all you need. If you now say to be calculated annually, what does that mean? What does calculated annually?
Generally simple interest in a normal commercial contract, but okay.
I guess, and again, that was not brought up below. There was no affidavit in opposition to that. They had their principal could have said that that's not the way. He didn't. So it wasn't brought up below, and again, I see no reason to undermine Judge Enghorn's decision there, when in fact it wasn't even raised. And the same thing with the discovery issue and the COVID issue. None of those were raised down below, and he could have. And had he asked for discovery, maybe Judge Enghorn would have given him discovery and said, you know what, I'll let him take a deposition, or I'll let him ask for some documents, and then you'll come back and make your motion. He didn't do any of that because he didn't ask for any of that.
And could you address the issue as to the operating agreement? Excuse me, as to the as to the operating agreement?
Which issue, Your Honor, concerning the operating agreement?
Well, because you're arguing, are you not, that in terms of the liability, you're arguing that it provides for joint severable liability?
Yeah, that's what it says in black and white English. They wrote that Yataki and will personally guarantee it jointly and severally. And for appellant to come in and say that this document was written by Sam Abraham with nothing in the record to that aspect, no affidavit, no anything regarding that, and it's just the pattern there. I mean, I've been doing this for 30-something years. I've never seen a brief without a single citation to the record. His initial brief has not a single citation to the record. He puts things in his reply brief that he now makes part of a record. So in terms of the liability, the individual liability, it couldn't be clearer. It says in that document, it says Yataki and areas are going to personally guarantee this jointly and severally. I don't know what else those words could mean.
Anything else? Any questions?
Unless there are any questions.
Thank you very much, counsel.
Thank you, Your Honor.
Pacelli versus Peter Cedeno and Associates.
Yes, good afternoon, Your Honors. This is Justin Kelton for the appellants. May I begin?
Yes, please.
Thank you. May it please the court. This is a case that involves a sexual assault by a matrimonial attorney against his client, and I represent the client, the plaintiff, below. This appeal arises out of a discovery motion, a motion to compel, and we have essentially three categories of items that we're seeking to compel. The first relates to the Victims of Gender Motivated Violence Act under the New York City Code. And the question presented is whether an allegation by a former client of this same attorney that the attorney was more interested in propositioning his ex-wife, who was per se opposing counsel in that matrimonial litigation, than in representing him, can constitute similar misconduct within the meaning of the VGM, which is discoverable to prove under the VGM that an act was motivated by gender animus, and also to establish right to punitive damages under the VGM. We contend, and we walk through in our brief, the case law that shows that the word similar, or similar, the concept of similarity, has been broadly interpreted under the VGM and under other very similar statutes dealing with alleged sexual misconduct. We cite three decisions from Justice Reed in Breest versus Haggis, a case that's being litigated now that in many ways is very similar to our case. And in all of them, he compelled the defendant to respond to allegations that are very, very similar to the same allegations that we have here, that this same defendant committed some other act of alleged misconduct. Here, the trial court found, and we believe in error, found that there's no possible way, even at the pretrial discovery stage, that anything that his correspondence with his pro se adversary, not related to the litigation, in other words, personal correspondence with his pro se adversary, could have any relevance to this VGM claim. But under the decisions we cite at page 15 of our opening brief, that's an error. We also cite the Gottwald versus Garagos case, which was affirmed by this court. And it says, I think importantly, that the court should err on the side of liberal discovery policy, since the defendant obtains the right to object to the admissibility of the evidence at trial regarding his purported prior sexual misconduct. It's the very same issue that's presented here. We cited these same decisions below. The court really didn't analyze them, and we think misinterpreted New York law. That's the first of the 3 points, and I'm happy to answer any questions about that. If there are none, I'll move to the second. The second of the 3 points is whether allegations that are expressly stated in the complaint are a proper basis for discovery. The allegations are relevant, but as a first threshold issue, the question is, there are these allegations in the complaint. They have never been subject to a motion to strike, so they remain in the complaint. The defendant did make a motion to strike other allegations and chose not to include these allegations. And so these allegations remain in the complaint, and the complaint is always in evidence, as we know. So we want to take discovery about these allegations to prove whether or not they're true, to prove whether or not the defendant was lying when he made these statements to my client, when he was pursuing a sexual relationship with her. And I think it's, again, very clear under New York law, and we cite a series of decisions in both of our briefs, that the allegations in a complaint are a proper subject for discovery.
This is Judge Scarpullo. What claim are your allegations that you want discovery on relevant to?
Okay. So they're relevant to the VGM claim, the breach of fiduciary duty claim.
Whether or not the guy has a gun, or he says he has a gun and he likes to shoot,
well,
this is relevant to the VGM claim. I mean, come on.
Well, they show his.
That claim isn't just a big bucket of dump everything in the world in it. Try another claim. Let's say no one thinks that's right. What other claim could that possibly be relevant to?
Well, Your Honor, it's not that we think it's a big bucket to dump everything in the world, and
that's exactly, you're holding on to that statute for everything.
Well, that is the main statute that we focus on, but you have to understand here that the plaintiff is alleging that he was trying to court her, to impress her, to intimidate her, to act like, for lack of a better term, a stereotypical, tough guy, alpha male persona, and that this is the way he did it. He made these claims to her at a time when she was highly vulnerable. And
my question again to you, counsel, is what does it matter if he does or doesn't have a gun? What matters is what he said to her. Well, whether or not he actually has the gun, or whether he goes to the shooting range 6 times a week, is totally irrelevant to whether or not he said that to her to get her to do something. So why are you going down that path?
Because if he was lying when he made those claims to try to get her into bed with lies, that would tend to establish the type of animus that is relevant under the VGM.
If it was true, what if it's true? Then your claim goes away?
If it's true, then that issue is not present, that he was lying. But
no, that's not right. It's whether or not he said it to her, not whether or not it's true. The truth or falsity of it has nothing to do with that kind of claim.
It's whether or not he said it to her, and what then that statement to her led her to do or not do.
Right.
That's what it goes to. So whether it's true or not doesn't matter. If he showed her the gun, if he waved the gun in front of her, perhaps then, but otherwise I don't see how it's relevant.
It's relevant to his bad faith in his interactions with somebody who, by the way, he had a heightened duty to as an attorney. He's lying to this woman that he's trying to sleep with at the same time he's trying to represent her. That would be relevant.
Again, let's keep in mind, this is not the trial court. You're not making your summation before the jury. So again, what other claims, do you have that this would be relevant to those claims? What else is there? What else do you have?
It's relevant for that same reason, I think, to more than one claim, but the reason is the same. So if the court's going to disagree on the reason, that's the court's prerogative. We respectfully take a different viewpoint. But these statements are in the complaint. There's a wealth of case law that says that, if you don't like a statement in the complaint, you can move to strike it. But if a statement is in the complaint, it's a subject of discovery. And the respondent has not cited a single case anywhere in any court from any jurisdiction saying that a party was not entitled to take discovery of its material factual allegations in the complaint. This complaint is going to be shown to the jury, and the defendant has not said, A, it's not true, or B, these are so scandalous and prejudicial and irrelevant they should be stricken. They're just saying you can't have discovery. And respectfully, I think that's the wrong legal approach, the wrong standard, and a bad precedent to set, and a precedent that doesn't exist currently.
Thank you. We'll hear from your adversary.
Your Honors, can you hear me?
Yes.
Okay, wonderful. I've been having some technical difficulties. Jamie Wasman for the respondents. The respondents respectfully request that the trial court's decision be affirmed in its entirety. On the first point, there's absolutely no similarity whatsoever with regard to the allegation at issue in the subject complaint, which is that defendant Cedeno raped Tessa Pacelli while he was her attorney. That is the allegation we have in the complaint, and the purportedly similar matter is a disgruntled ex-husband's unfounded claim that defendant Cedeno flirted with the former client's pro se adversary wife. There is absolutely no similarity with a flirtation, alleged flirtation with an adversary to an alleged rape of a current client. Moreover, the ex-husband filed a grievance complaint against defendant Cedeno, and the First Department looked into the complaint. There was an answer, there was discovery, and the First Department determined not to move forward with it because there was no misconduct. So not only is there no similar conduct, there was no misconduct with respect to Ms. Garanza. Therefore, the plaintiffs have overwhelmingly failed to show the relevancy of interrogatory 33 related to Ms. Garanza and any communications my clients may have had with her. And the trial court appropriately concluded that the motion to compel a response to that interrogatory should be denied. As to the second point, I think all of your honors have recognized that there's absolutely no relevancy whatsoever as to whether or not, for instance, my client had a crossbow, because that has nothing at all to do with the requisite elements that must be proven in order to prevail on the actual causes of action that are set forth in the four corners of the complaint. Plaintiffs seem to rely upon the VGM claim and try to tie some sort of connection as between the ownership of a crossbow or a handgun
speeding above 25 miles per hour and an alleged violent act against a woman motivated by gender animus. And as the trial court correctly concluded, there's absolutely no relevancy between the two. Finally, on the third point, the plaintiffs also sought any documents related to travel that my clients may have engaged in between June 3rd, 2016 and August 10th, 2016. The trial court, again, appropriately held that this request was entirely irrelevant to the matters at issue in the complaint. It had nothing to do with the causes of action set forth in the complaint. There's no allegation whatsoever pertaining to travel. There's no allegation that my client said that he was unavailable for any period, let alone the 2-week period in which my client purportedly delayed the resolution of the underlying action so that he could seduce Miss Pacelli. Therefore, the court appropriately held that any hypothetical, and that is directly from the court's decision, any hypothetical travel documents relative to my client's travel between June 3rd, 2006 and August 10th, 2016 had nothing to do with the claims and therefore was not relevant to any of the causes of action. Unless the court has any questions for me, I will rest on my brief.
Any questions? Thank you very much. Thank you both.
Thank you.
Next matter is Rizzo versus the estate of Polifrone. Appellate,
thank you, Your Honor. Good afternoon, and may it please the court. Katrina Jones for the appellant. The appellant appeals 2 summary judgment dismissals entered against her, dismissing the case in full against defendant doctors, the estate of Joseph Polifrone and Anna Rose Polifrone, father and daughter. She filed her underlying claims based on a fraud that can substantiate claims for medical malpractice, fraud, negligence, and gender discrimination, harassment, and sexual abuse. In addition to her claims against the defendant doctors here, she also has a claim against Anthony Polifrone, who was the son and brother of the defendant doctors who performed physical therapy on her without a license and after and before he was in school for physical therapy doctorate. We believe that the lower court erred in dismissing the case in full because the petitioner has valid claims for fraud and malpractice and violations of the human rights statutes of city and state for under the public accommodations clause, which does apply strict liability for such actions by an employee or agent against a member of the public using that public accommodation. Ms. Rizzo, the petitioner started seeing the Joseph Polifrone, Dr. Joseph Polifrone in January 2005.
So she goes to see Joseph Polifrone, and he refers her to his daughter and also for treatment by his daughter. And then he also, apparently his son also treats her as well. So you have a med mal claim against the father, Joseph, as well as the daughter, or just the daughter?
Just the daughter at this time, Your Honor.
And so the claim as to the daughter is apparently that she gave your client some type of an injection, and then your client, based upon that injection, sustained some type of reaction, causing her to go to the emergency room. Is that the claim?
No, Your Honor. We've limited our medical malpractice claim against the Dr. Anna Rose Polifrone to the events surrounding her allowing an unlicensed physical therapist to perform physical therapy on our on the client, and also to allow and the injuries that stem from that, which included sexual assault and during a treatment.
So it's as to some type of negligent hiring or negligent supervision of the brother?
Yes. So Anthony Polifrone, who is the other defendant and the brother, he was enrolled in physical therapy school for a doctorate in physical therapy. His enrollment started somewhere between May 20th and 22nd of 2005. He testified that after he had back surgery in August of 2005, he no longer was able to be enrolled into the physical therapy program because he could not perform all the functions required in the job. However, he continued to work in both offices and give physical therapy until 2008, when he assaulted the petitioner during the course of physical therapy, quote unquote, in February 11, 2008.
But your negligent hiring and retention argument is not based upon his alleged inability to perform physical therapy. It's based on his allegedly assaulting her. I'm not really clear what his, whether he was actually allowed to perform physical therapy or not allowed to perform physical therapy has to do with your argument.
If I understand your question, Your Honor, our basis is.
And the reason I'm confused, I must be honest with you, is because your complaint is very confusing. You throw a lot of different claims and arguments in, so that's why I'm a little bit confused as exactly, what your claims are. Because you're saying that the female doctor, she should have known that her brother had some type of propensity to commit an assault, a sexual assault.
Oh, no, Your Honor, that's not our claim. So for the negligence, I'm going to start there. So I make sure that I'm going to try to hit everything that you brought up. For the negligence, we're saying that she was negligent in allowing someone that was not authorized to perform physical therapy for the reasons listed in our brief in chief. You have to be in school and supervised by a physical therapist in order to be a physical therapist intern, and then to perform physical therapy in a clinical setting. And he was not. He was supervised by his sister or his father while he worked in their respective offices. Additionally, for most of the time that he was performing physical therapy, he was no longer in school. So the negligence in hiring, retention, and supervising comes from the fact that he was not allowed to work in that medical capacity and do those kind of physical therapy appointments and modules that he was allowed to do in the doctor's offices.
Ms. Jones, Justice Kennedy,
any type of injury as a result of that? That's what I'm not understanding. What are you claiming that? What injury are you claiming that she sustained as a result of his not being certified to perform physical therapy?
So the injuries are from the sexual assault and battery that she was. I'm sorry, that the sexual assault and battery that happened to her in February of 2008. The reason why. I'm sorry,
Justice Kennedy had a question. Justice Kennedy?
Ms. Jones, I just want to go back to your city HRL claim, because you're now basing it on a place of public accommodation. But did you argue that below?
That it was a place of public accommodation?
Correct.
Yes, Your Honor. We said that it was a public accommodation. It was a doctor's office where the treatment and the assault happened. And the part of the New York City human rights law that deals with public accommodation has a specific strict liability for discriminations in places of public accommodation.
Well, Ms. Jones, I don't recall seeing that, but let's say that you are correct on that point. I just don't see how this is applicable because Joseph was not an employee. You have to be an employee for that claim to be applicable. Wasn't he an independent contractor here?
You said Joseph, Your Honor. Did you mean Anthony Palafrone?
I apologize. It's late. Anthony.
No, I just want to make sure that I'm answering the right
Anthony.
question. My
Anthony,
apologies.
yes.
So, I, for the reasons in our brief in chief, I believe that he qualifies as an employee. But even if the court does not accept him as an employee, he was acting as an agent of both doctors because he states that they supervised him. They gave him work to do. They made his schedule. They made the plan. So he acted on their behalf in giving the physical therapy. He worked out of their offices. Does that answer your question?
Well, just one more and then I'll stop because I don't recall seeing any documents to actually prove that he was an employee. No financial records or anything to indicate that he was an employee.
Well, there were not financial records, but he testified, Anthony Palafrone, that he was paid, that he Dr. Anna Rose Palafrone testified that she paid for workers' compensation. She testified that she made his schedule, that she supervised his work.
Thank you.
Thank you.
Justice Scarpula, I'm sorry, did you have a question?
I just wanted to ask you, are you saying that but for the fact that he wasn't licensed as a physical therapist, he wouldn't have sexually assaulted the decedent?
No, Your Honor.
Isn't that what your claim is? You're claiming that the negligence was allowing someone who wasn't licensed to sexually assault her. I think that's what you just said.
So my claim is actually that, but for the fraud. So the
what fraud? Now I'm even more confused.
Okay. So the fraud
what fraud
was
are you talking about?
that they held him out to be a physical therapist and or a physical therapist intern, however you want to term it, when he was not, in fact, an appropriate person to do that. Both the first time that she got physical therapy from him, he wasn't even in school yet, and when she was assaulted, he wasn't in school anymore. So if they not,
that's the causation of her assault is him not having the piece of paper.
No, the causation is that they allowed him to perform physical therapy when they knew he was not a person that could do physical therapy.
So that's my question. How does that affect, or what does that have to do with his allegedly sexually assaulting him? I mean, even if he was a physical therapist, suppose he was certified as a physical therapist, does that, under your argument, does that then relieve them of any liability for sexually assaulting her?
Well, I think that this is a special situation because they acted together to do this fraud and to hold him out as physical therapist. And but for that fraud, he wouldn't have been in that position.
So your argument is
give her physical therapy.
Your argument is because they engaged in this conspiracy or knowledge that he wasn't a physical therapist, therefore they are liable for anything for any of his actions, including allegedly sexually assaulting her.
Respectfully, I believe so, because who knows what the outcome of a fraud would be. So,
is your argument based on anything in the law, any cases or any statute or any reading of the law?
So I did in our brief in chief, I did cite cases that said in our reply brief, I cited cases that said that medical administration actions of negligence and fraud can be but for, I'm sorry, let me rephrase that. Withholding information can be a but for a cause of fraud or gross negligence by medical providers.
Well, we'll take a look at that, and you have time on rebuttal. I've given you far too much time. Next up is the estate of Joseph Profilone. You have 4 minutes. Hello?
Can you hear me now?
Yep, we're good.
Okay, sorry. You obviously heard nothing that I just said.
No.
Gregory Casino for the defendant respondent, the estate of Dr. Polifrone. Your Honor, this was an intentional assault done for purely personal reasons, having nothing to do with the care and treatment that the plaintiff was being provided by Anthony Polifrone. And the law is clear that where a hospital employee commits a sexual assault, such conduct can never be in furtherance of the patient's care, and therefore can never be the basis for vicarious liability. The law does recognize this idea of negligent hiring, negligent supervision. If this was a malpractice case and there was some sort of claim of negligent hiring and negligent retention or negligent, of a doctor of some sort, and the plaintiff was actually injured by the medical treatment, then perhaps the fact that the plaintiff was not, that Anthony Polifrone was not in the school at some time or was somehow a bad physical therapist, that might be relevant. But what they're claiming
is he even is Anthony even an employee, or is he an employee?
Your Honor, you jumped to my next point. He's not an employee of Dr. Polifrone. But basically, Dr. Polifrone recommended that the plaintiff undergo treatment by Anna Rose Polifrone, and then she referred plaintiff to Anthony, who was about to enroll in a PhD program. And then during these sessions, Anthony was supervised by Anna Rose and not Dr. Polifrone. So he really has nothing to do with these therapy sessions.
Practice. Wasn't it your client's practice though? And working together with his daughter as well as his son, and I think another daughter. But wasn't it in all his practice?
I believe it's in the same building. It's a family practice, yes. But again, Anna Rose Polifrone repeatedly testified that she was the one who was supervising Anthony during all this time. Now, I know the plaintiff made something about the fact that that Joseph Polifrone made some payments to Anthony Polifrone. But that was clearly for having to maintenance, building maintenance, because he owned the building that the practice was in, having nothing to do with this.
Well, that's what Anthony testified. Didn't Anthony testify to that he would do some things in the around the office, and that's what he was being paid for, and he wasn't really being paid for actually administering any treatment?
Exactly. And the alleged sexual assault has nothing to do with the building maintenance. But even if he was an employee, the law is clear that, they have this other theory. There is this other, what a lot of these cases also discuss in all the cases I cited in my brief, it's kind of like a two-step analysis. You still can't hold them you still can't hold them liable under a negligence theory. That would be, Dr. Joseph Polifrone, that they negligently retain, they negligently supervise for it when there's an intentional assault by the person. We're not talking about negligence by the putative employee. We're talking about an intentional assault by the employee. Yes, there is a line of cases, and there's theory where you could hold them where you could hold the putative employer liable under a negligence theory, but that would have to show that there was some sort of prior bad acts by the putative employee. And if you look, the plaintiff, in the plaintiff's brief, it's very interesting. There's a couple of lists that the plaintiff says. One is on page 14 and one is on page 30 of the plaintiff's brief. And she goes forward with all these different lists of things that she believes, of issues that she believes are in this case. None of those issues that she says in this case is whether or not my client, or not even the co-defendant, but my client was aware of any prior incidences which would have put him on notice of some sort of propensity by by Anthony that he was going to commit some sort of act. It appears that this was a one-off act, that it would never been. There's no evidence that he had ever done anything like this before, and so that therefore there would be no basis to hold him liable under a vicarious liability theory or under a negligence theory. And that's, again, that's also assuming that he is an employee, and we submit that he's not an employee. We submit that the New York City human rights law does not apply here. That's just simply an end run to try to get around all the Court of Appeals cases and the cases from this court where they dismissed claims against the employer based on sexual assault by the employee because there was no notice of any propensity or anything even remote, anything close to that, to no reason to hold the person liable. So she doesn't get the benefit of she can't simply just say that this is a, that this is a strict liability claim, because otherwise all those cases would have come out the opposite direction because they all occurred within the city. And if there's any further questions, I'm sorry, if there's no further questions.
No, thank you very much. Counsel for Anna Rose Perplum.
May it please the court, I'm Danielle Bennett with Coster Brady and Nagler on behalf of Dr. Anna Rose Palafrone. As Mr. Casino said, this is a case where plaintiff is trying to find any avenue, no matter how frivolous, to hold Dr. Anna Rose Palafrone and Joseph Palafrone liable for the sexual assault she allegedly suffered at the hands of another person.
Well, do we have anything in the record that Anthony was an employee?
That's a disputed fact. I mean, you have the testimony that Anna Rose Palafrone supervised the physical therapy of Anthony, but she wasn't even present in the office on the day that he allegedly sexually assaulted her. She wasn't in the Bronx office on that day, and she never gave treatment. And Anthony Palafrone never gave treatment to the plaintiff in her office. And so that's disputed. But even assuming he was an employee, as Mr. Casino said, there's no basis to hold Anna Rose Palafrone vicariously liable for a sexual assault by Anthony Palafrone. There's just absolutely no evidence that the plaintiff sustained any injuries from the treatment rendered by Anna Rose or the physical therapy by Anthony. So these purported issues of fact that the plaintiff is raising regarding the status of Anthony Palafrone as a physical therapy student and whether he was told that he was a physical therapy student are not material here, because the plaintiff has not made any rational link between these factorial issues and the sexual assault allegedly committed by Anthony Palafrone. Even if Dr. Anna Rose Palafrone was an employer of Anthony, and even if she did tell the plaintiff that Anthony was a P2T student and it wasn't, the fact is that the plaintiff wasn't injured by the physical therapy administered by Anthony Palafrone.
So that goes to the plaintiff's fraud complaint as well, right? The fraud cause of action.
Right. Basically, as Mr. Casino said, the law is very well settled that if an employer is going to be held vicariously liable for these intentional torts, such as sexual harassment or assault, there has to be some notice that on behalf of the employer that the employee had the propensity to commit these acts, or that it was foreseeable that the employee could somehow have harmed her patients, and there's no evidence to that fact. The only way to get around this is strict liability, which is why plaintiff's counsel and the plaintiff is trying to toss in now the NYC human rights law claim. However, the entire basis of the claim based on violations of the human rights law is based on a New York County Supreme Court case that isn't authoritative here and, in my opinion, overextended this court's holding in previous decisions. If this court were to adopt the plaintiff's argument regarding the NYC human rights law, that would essentially be saying that every single employer of or owner of a public accommodation at NYC would be strictly liable for the sexual assault by their employees, which, it can't be argued that that was the legislative intent of the city council when they enacted that statute. It would essentially throw out the window hundreds of years of decisions regarding an analysis regarding employer liability for intentional acts of an employee. So aside from strict liability, which I just argued there's no basis for, we submit that there is no basis in fact or law to hold Dr. Anna Rose Palafrone liable for the sexual assault by another person. if there aren't any other questions, I'll rest on my brief.
Did you have a question, Justice Scarpula?
I just wanted to ask you about, are you saying that it is actually disputed whether or not, you're saying that there is an issue of fact, whether he was an employee?
There's not an issue. We are arguing that there is no issue of fact as to whether he was an employee.
Okay, because I thought you said there was an issue of fact. That's what I was unclear.
Plaintiff is disputing it, but we.
Of course, yes. I'm just asking because I thought you said there's an issue of fact.
No, I'm not conceding that there's an issue of fact on that issue. I'm saying that plaintiff is disputing that.
Thank you.
Thank you. Ms. Jones, you have 2 minutes.
Thank you. First, I wanted to say that there is no notice requirement as far as our allegations of fraud. And the elements of fraud are clearly present in this case, including constructive fraud because of the fiduciary nature of the doctor-patient relationship in this case. Additionally, at the very least, Anthony Palafrone was an agent of both doctors because he was someone who was authorized to act for them in their place on their behalf. Additionally, Anthony Palafrone testified that Joseph Palafrone supervised his work and sometimes stood over him while he administered physical therapy to patients. Additionally, the New York human rights law is not a new claim in this case. It's not something that we came up with and sort of threw in at the last minute. It has always been a viable part of this claim. The New York City human rights law created a special caveat for places of public accommodation, like doctors' offices, to create liability for employees, agents, owners of those places. I did want to point out that after the briefs were due in this case, in Doe versus Bloomberg, the Court of Appeals said that there was direct liability for places of public accommodation. So they didn't go as far as say it was strict liability, but they said there was direct liability for owners, managers, and agents or employees of places of public accommodations. And that was on February 11th of this year. So for all these reasons and all the reasons put forth in our briefs, we believe that the lower court erred in dismissing these cases in full, and we respectfully request a reversal.
Thank you very much.
Thank you.
Palermo versus 7 West 21 LLC.
Good afternoon, Your Honors. May it please the court, Michael Zhu on behalf of the plaintiff appellant Frank Palermo of counsel to Saxton and Lee. We believe that the trial court here erred in denying the plaintiff's motion for partial summary judgment as to liability on his labor law 240 sub 1 claim. It erred in holding that the plaintiff was required to show that the devices that he identified, which included either a dolly or a handcart, are of the kind that was envisioned by the labor law. That's simply not the requirement of a plaintiff seeking partial summary judgment.
Mr. Counsel, this is Judge Owing. So this is my understanding of the facts here. You have this wood foam, which is a mold to pour concrete in to mold these pillars or walls in the construction project, correct?
Correct.
And that had occurred without incident, and your client and another coworker's task was tasked to take the mold off, the foam, take the wooden foam off the wall now, right? And
Yes.
that was also done without incident. And they're now, the two of them, as they remove the foam, as your client's EBT reveals, they're about to move, and then the coworker says, wait a second, I got to move some of this debris that's in front of me. So he puts down his side of the foam, right? And then your client takes his side and rests it on pipes that are coming through the floor, and it's now resting without incident.
They're
Right.
both on pipes. His end, the coworker's end, and the plaintiff's end are both elevated off the ground.
That's not what he testified to. He testified that he put it down. His coworker laid the foam down on the ground, and
Okay.
his end was up. So there was like a It was like it's like on a slant now. That's what he testified to.
Okay, I'm sorry, I apologize. Then my understanding, my reading of the record was that both workers had both their ends.
Okay.
Okay, I don't think it matters.
Okay.
For purposes.
Let's say for you is correct. Okay, they're both elevated at that point.
Sure.
Without incident, the foam is now resting on the pipes.
Correct.
Right?
Yes.
So he moves away, and then his coworker then takes the pipe, takes his side of the foam, moves it, and then the other side, of course, he didn't see. Your client doesn't see it, gets moved and falls and hits him on the foot.
Correct.
How is that? So where is it exactly then? Is there a safety device that can be used to prevent that situation, or that's the protective device under the 240?
Well, this court said it itself in Aramburu, where the court held that rather than using plaintiff as the securing device contemplated by the statute, he should have been provided with one instead. And that's at 12683
What is the safety
499.
device that's elevated, that's set forth? What is enumerated in 240 that should have been provided to him?
How about a dolly or a cart?
I'm sorry?
Dolly or a cart to move these things.
Does 240 say dolly and cart?
No, but I don't think my burden is ever to have to show that I need X device to be provided in order for me to bring.
I agree with you, because 240 says these devices are other enumerated devices.
Right, and the other.
Yeah. Go ahead.
The other enumerated device would be a dolly or a hand cart.
That's your contention. You got a case that says actually that?
That says that.
argument,
I'm
the
sorry, do I
dolly-
have a case that says that a dolly or a hand truck needs to be provided?
No, that's an enumerated device in the 240.
Apologize.
Oh, you're freezing out. Maybe the questions were so was so profound that you froze. I froze him. I'm sorry. Mr. Zhu, you're frozen. Okay.
Back now.
Okay, you're back. So yeah, is there a case that says a dolly or is a enumerated device on the 240?
No, I don't have a particular case that says that, but I do have a lot of cases that say safety devices should have been provided to workers who are
moving. That. I'm agreeing with you. Okay, fine. Let's assume I agree with you that a safety device had to be provided, but is a dolly an enumerated device on the 240? That's all.
I can't say that I have any cases. Otherwise, it would have been the first case that I cited in my brief, Judge.
Because I looked too, and I couldn't find it. Okay, fair enough.
Yeah. Yeah, but in any event, I don't think it's my burden to say that, again, at the risk of repeating myself, that a dolly or a hand cart has to be provided.
I gotta say something, but you're moving for summary judgment. You may not have the burden, but you're moving for summary judgment. You got to demonstrate prima facie that you're entitled to summary judgment, that you ticked off all the boxes, and that you should get summary judgment. So when you say it's not your burden, it's not your burden. You had the prima facie burden.
Burden, but again, prima facie burden.
You keep freezing.
That inadequate devices or adequate devices were not provided an elevation related.
Yeah, you're freezing. Okay, counsel, thank you. We're going to turn to the respondent now.
Oh, you're on mute.
Oh, I just unmuted myself. Does everyone hear me?
Yes, thank you.
I'm not
Good
going to ask a question. I might freeze you if I ask a question.
Good afternoon, Your Honors. May it please the court, Roxana Krasovitskaya for the respondents. Simply put, in our opinion, this is not a labor law 240 case. Plaintiff's accident was caused by his negligence as well as his coworker's negligence. It is clearly established in plaintiff's own deposition testimony that he was allegedly injured when he failed to pay attention to what his coworker was doing, and that his coworker did not communicate well and simply just released the form before plaintiff was able to, when plaintiff turned away. And as such—
So this is Judge Scarpula. If a dolly had been given to the plaintiff and he put the form on the dolly or the foam or the form, the accident wouldn't have happened, correct? It couldn't have fallen because it would be on the dolly.
Well, right? My understanding of the accident
The question is, again, it's your position that it was negligence, and the plaintiff's position, if you had given me this device, this accident couldn't have occurred. So why is that not an issue of fact?
Your Honor, respectfully, we believe that it is not an issue of fact. We've provided an affidavit from expert Robert O'Connor, who affirmed that in terms of when you remove wooden forms from the wall and when you transport them, you do not need any safety devices. And so plaintiff was injured, allegedly, when he and his coworker rested the form on top of two pipes. He was not injured when he was transporting the forms. A dolly and A-frame cart would not have prevented his accident. And furthermore, there is no indication
does that matter if they're walking along and it drops on his foot as opposed to how the accident occurred? You're saying that that would not create a labor law cause of action?
No, our position is that simply it was not needed. They were just transporting it. Even George Olmo, our own defense witnesses, have all said that there's absolutely no need for A-frame devices or dollies to be provided.
Well, I would be surprised if the defense witnesses said, yes, they should have had a dolly, right? That would have really been a surprise if they testified to that.
And may it please the court, in reviewing all of the cases that plaintiff's counsel indicated in his brief, none of the cases were similar in any way to this fact pattern. They all included objects that were overhead and that needed securing, and none of them indicated that dollies or A-frame carts were enumerated devices in Labor Law 240. And so it is our position that, once again, plaintiff's moved for summary judgment. Now he's appealed the lower court's decision, and still has failed to put forth any evidence indicating why dollies or A-frame carts were the enumerated safety devices in the statute that would have prevented plaintiff's accident.
Thank you.
Thank you.
Leader to admit you to the.
Yes, I apologize.
I'm sorry, you have 2 minutes.
I do. Okay. And I just wanted to clear something up. Justice Scorpula asked some questions that was interesting, and I was caught off guard here by defense counsel's responses. Defendant did not move for summary judgment, so she didn't seek to dismiss my Labor Law 240 claim. So however this court decides to rule on this appeal, my claim stays. I may or may not get summary judgment, but under no circumstance should the defendant receive summary judgment and a dismissal of the labor law claim. Now, going back to the arguments, to the substantive arguments, again, it's my burden on summary judgment on 240 to show that a violation of this statute has occurred, and here it's plaintiff's position that the failure to provide a dolly or a hand cart is a violation of the statute that was a proximate cause of the plaintiff's injuries. And unless the court has any further questions, I'll rest on my brief.
No, thank you very much.
Thank you.
People v. Santino Guerra.
Good afternoon, Your Honor. May I begin?
Yes, please.
All right. Good afternoon, and may it please the court. Patrick Updike of Winston & Strawn for defendant appellant Santino Guerra. This appeal is about an antiquated evidentiary rule that puts New York in the much criticized minority of jurisdictions and hamstrings criminal defendants in various self-defense cases. It arises from a verdict finding Mr. Guerra guilty of assault in the second degree based on an altercation with Dylan Pitt on St. Patrick's Day in 2016. We ask this court to reverse Mr. Guerra's conviction and dismiss the indictment for 3 reasons. First, Mr. Guerra was prejudiced by his inability, under People v. Miller, to introduce evidence that Mr. Pitt, a man with a significant history of violent and assaultive conduct, was actually the initial aggressor in the altercation with Mr. Guerra.
Did Mr. Guerra know that? At the time of the altercation, did Mr. Guerra know of Mr. Pitt's history, propensity towards violence?
He did not. They were strangers.
So how then would that go to his intent, or whether or not he could show that he was acting with some type of justification?
I understand, Your Honor, and under the rule announced in Miller, you are correct. However, our argument is that the rule in Miller is fundamentally unfair because it prejudices defendants when it comes to situations like this.
Okay, so I understand that. So why then would Mr. Pitt's prior interactions or prior assaultive behavior, why would that be relevant to Mr. Guerra's trial?
So Mr. Guerra sought to, excuse me, introduce that evidence to demonstrate that Mr. Pitt has a propensity for initiating assaultive altercations with various strangers, not to show that Mr. Guerra was necessarily reasonable in using and deploying force for self-defense.
So wouldn't that be pure propensity, so that the jury would then so that you could argue to the jury, well, look, in all these other instances, Mr. Pitt was the initial aggressor. So, hey, he must have been the initial aggressor in this case as well, because this is basically what he does. How is that not propensity and to some extent also speculating as to what occurred, as opposed to making a determination as to exactly what occurred in this case based upon the testimony presented?
Thank you, Your Honor. For a couple of reasons, I think this information would be highly probative without being unduly prejudicial, and because at the very least it demonstrates, consistent with the testimony, that Mr. Pitt's group of friends encountered Mr. Guerra as he was crossing the street innocently enough, and Mr. Pitt's friend, Mr. Kane, first commented on Mr. Guerra's black eye that he had received a few days prior from a different assault that he was the victim of, and called attention to Mr. Guerra's black eye, and then the altercation escalated from there, with Mr. Pitt and Mr. Guerra further exchanging words, and then so on and so forth.
Counsel, was there any evidence that any of Mr. Pitt's friends threatened the defendant or had any weapons?
No, Your Honor. The mere proximity of Mr. Pitt's friends to Mr. Guerra, I think, added to the potential threat, that they had called attention to his black eye and began exchanging words with him as Mr. Pitt approached him, and according to Mr. Guerra's testimony, swung a glass beer bottle at him after the group had already been drinking at least a fair amount of intoxicating beverages before the altercation. And to circle back, the trial court ruling basically afforded Sandoval-like protection to a non-defendant witness for the people, whereas the holding under Sandoval, People v. Sandoval, is that when it comes to cross-examination of a defendant, the people must the people's right to cross-examination must be balanced with the defendant's right to a fair trial. But there is a substantial amount of case law that supports the conclusion that that type of protection, the Sandoval-like protection, does not extend to a witness, a non-defendant witness, because there is no risk that a juror would apply evidence of any prior misconduct to anything other than the witness's credibility.
Sure. In this case, certainly there would be. You have Mr. Pitt stating that he was not the initial aggressor. You have individuals with him stating that he was not the initial aggressor. So now you want to bring in testimony stating that in other instances he was the initial aggressor. So that would kind of break the tie, right?
Yes, Your Honor, and I think
would that not then be prejudicial? Excuse me, but yeah, would that goes towards propensity, and so that would inherently be unfair, wouldn't it?
I don't disagree that it would be potentially prejudicial to Mr. Pitt, but as a non-defendant witness for the people, I think it would not be unduly prejudicial, especially because the trial court could, as it had, issued an instruction to the jury to cure any potential prejudice.
So what would be the purpose? We're going to allow testimony as to Mr. Pitt having engaged in these prior altercations. But we're gonna charge you that don't take that as to show that Mr. Pitt acts in any specific way.
Yes, Your Honor. So I believe that the trial court actually issued an instruction to the jury, seemingly under the guise of adhering to Miller, instructing the jury that they should not consider Mr. Pitt's prior violent acts as evidence on the initial aggressor issue. And apart from the potential fundamental unfairness that results from the application of Miller, this has also prejudiced Mr. Guerra's constitutional right to confront his accuser, and consistent with the line of case law identified in our briefing, basically stating that Sandoval-like protection should not be afforded to a non-defendant witness.
Any questions? Thank you. People?
May it please the court, Charles Wong for the respondent. Your Honor, it is well established that evidence of a victim's prior violent acts is not admissible unless the defendant had prior knowledge. And here, the defendant concedes that he had no such prior knowledge as the defendant and the victim were total strangers. So the trial court properly precluded defense from introducing such evidence at trial. And here, a bystander who was unrelated to both the defendant and the victim testified that in an open street, it was just basically the defendant and the victim facing off each other, and that the victim did not make any aggressive actions toward the defendant when the defendant took out a knife and stabbed the victim in the chest. And even by the defendant's own testimony, he had ample opportunity to retreat in this case. So therefore, the evidence was overwhelmingly proved defendant's guilt and disproved his justification defense here. If your honors have no questions, I will rest upon our brief and request an affirmance.
Any questions? Thank you both. Thank you very much.
Thank you.
Correa versus Mana Construction.
Good afternoon, Your Honors. May it please the court. James Baez for the appellants. Your Honor,
Lost you. Ms. Baez, hello?
Can you see me, Your Honors?
We don't really need to see you, but we just need to hear you, but we can see and hear you.
Okay, great. I apologize.
That's okay.
Your Honors, our main argument in this case is that the city was on written notice of the defect that caused plaintiff's accident from the Big Apple maps that were provided in the city's own discovery responses, stating that there was raised portions of the sidewalk immediately in the area of where the accident occurred. And
so I'm sorry, you're saying that in the record that shows that there was written notice to the city as to a defect near the manhole?
Yes, Your Honors. Our argument is that the Big Apple maps that were provided and were cited to in our argument is the prior written notice that the city had for this defective condition. And the case law states that Big Apple maps stating those defective conditions in that area would provide.
I thought the Big Apple map showed a cracked sidewalk at the corner of 180th and Prospect, and also a raised or uneven portion of the sidewalk at the subject corner.
That is correct, Your Honor. And is
that where the manhole was?
Yes, Your Honor. The manhole is exactly on that corner. And Your Honor, I'll point to specifically to, I apologize, Your Honor. I had the page pulled up. It would be page 253, Your Honor. And the circled portion of it is where plaintiff's accident happened. It was exactly on that corner. And it is our.
Wait, I'm sorry. So this is the manhole cover.
Your Honor.
These maps show an issue with the manhole cover, which is where she stated that she fell over.
Well, Your Honor, it's the exact diagram that's used and the actual I apologize, Your Honor. What's used in the Big Apple maps doesn't specifically have one that specifies 4 manhole covers, but it is our argument that the client testified that this particular portion of the sidewalk was at a higher level than what the manhole was at. And that is what we're stating there.
In her 58, she was asked 8 different ways. What are you talking about? And every single time, in every single way, she said, I tripped because the manhole cover was depressed, and there was a difference between the manhole cover and the sidewalk. I mean, she could not have been clearer. She didn't testify about the corner. She didn't testify about a crack anywhere else. That's what she said happened. And then the Big Apple map says nothing about the manhole cover, right? It says there's a crack on the corner, but it doesn't say anything about the manhole cover. Do we agree? Let me ask you first, do we agree that if there was something on the Big Apple map about the manhole cover, it would have said something about manhole cover, not crack on the corner, and that there was nothing there?
Your Honor, I will state that the Big Apple map does not state anything specific about the manhole cover itself.
Specific. Does it say anything at all about the manhole cover? I'm not even going to go specifics. Anything about the manhole cover.
So, Your Honor, in the area where it is shown on page, I apologize again, page 253, the manhole cover is exactly in the portion where there is a designation for cracked and raised sidewalk. It is in the exact same place. It's not where it is circled, is not, the manhole cover doesn't exist in a separate area that's outside of that. It is actually inside of that circled area. The manhole cover is exactly on the corner where the
lost you.
I apologize, Your Honor. During everyone else's arguments, I've been experiencing the microphone giving out, but not my video so far. So I apologize. Can everyone hear me?
I lost you at some point. So you're stating again that the manhole cover and some type of defect to this manhole cover is shown in the Big Apple photos?
That is our argument, Your Honor, because the raised portion of the sidewalk as well as the crack is in the exact same position of where the manhole cover is, and our client's testimony is that the sidewalk was at an uneven level as to where the manhole cover was. We're stating that the raised portion of the sidewalk shown on the Big Apple maps gave the city written notice of the uneven raised sidewalk that surrounded this manhole cover.
Okay, Justice Scarpula has a question.
Yes, I apologize, Your Honor.
What do you do with the city's testimony that there's a separate symbol for manhole covers than there is for regular cracks on the sidewalk, and that symbol is simply not on the map? Do you have anything that disputes that statement by the city of New York?
Your Honor, my understanding of the city's arguments on that is that they indicate that if there was a defect for the manhole cover itself, it should have been a clear circle with nothing on it to indicate a depression in the sidewalk itself.
And we all agree that that's not there.
Yes, Your Honor. I will state that circle is not located at this particular corner. But however, from how the client testified, how my client testified, she indicates that this manhole cover was at a separate level than the raised portion of the sidewalk that surrounded it. So it's our argument that the written notice in the Big Apple maps of this raised sidewalk, which itself, if it raises up, would then also be at a higher level than the manhole cover itself, is the written notice of the defect which caused the client's injuries. And it's would I have liked it if Big Apple maps included that particular? Absolutely, Your Honors. But in regards to what's actually shown there is a tribal issue of fact of written notice in regards to what is put on the Big Apple maps.
And Mr. Byers, just to go back, so the notice of claim, the 50H, the complaint, and the bill of particulars all says manhole, correct?
Yes, Your Honor, that is correct.
And then, because I'm actually looking at it, page 231, she circles where she fell, circle around the manhole.
Yes, Your Honor, that is correct.
Okay, thank you.
And Your Honor,
you have time on rebuttal, Ms. Byers. City?
Thank you, Your Honor. My name is John Moore, and I represent the City of New York. The Supreme Court correctly granted the city summary judgment because the city did not have prior written notice of the defect that plaintiff alleges caused her to fall. To avoid that result, plaintiff attempts to change her allegations and then change the legal standard that governs these claims. This court should reject both attempts and should affirm the dismissal of her claims.
Is there any way we can view the Big Apple photos as also indicating some defect to the manhole cover where plaintiff claims that she fell?
No, there's not. For that point, I would refer your honors to the Roldan versus City of New York decision from this court, which dealt with a very similar issue where the plaintiff alleged that the plaintiff in that case alleged to having fallen in a hole that was about 12 inches in diameter, which would be, for what it's worth, I think smaller than what a manhole cover would be. The court in that case said that a notation on the Big Apple map that there was a raised or uneven sidewalk was not prior written notice of the hole there. And the reason for that is very straightforward. And if you look at pages 235 and I think 252 of the record, their Big Apple maps contain a notation for a hole or hazardous depression. That is exactly what plaintiff described here. And if you look at pages 52 to 55 of the record, that is her deposition testimony. I would encourage the court to read it in its entirety to the extent that you haven't already, because the plaintiff was crystal clear. I fell in a hole. I fell because the metal of the Con Edison manhole cover was depressed compared to the sidewalk around it. There's a symbol for that on the Big Apple map, and as plaintiff conceded today, that symbol does not appear on the Big Apple map for this location. Turning very briefly to the question of cause and create, Yarborough sets out a very clear standard that once the city, as we have, establishes that there is no prior written notice, it is plaintiff's burden to show that an exception to that rule exists. For instance, that the city caused or created it. Now, plaintiff has never addressed Yarborough and never cited Yarborough in either of his briefs or today, nor has plaintiff ever offered any evidence that the city caused or created this defect. There is simply nothing to suggest that the city had done so. Where the city doesn't have prior written notice, and we met our prima facie burden there, and plaintiff has offered no evidence to overcome that burden as required by Yarborough, summary judgment was correctly granted and should be affirmed. Unless the court has any further questions, I'm happy to rest on my brief.
Any questions? Thank you very much.
Thank you.
Ms. Baez, you have, I think you have 2 minutes.
Yeah, Your Honors, I won't rehash the argument about the raised sidewalk. It's our position that raised sidewalk would naturally cause a depression in anything that isn't raised up with it, and that is shown in the Big Apple maps. And in regards to council's position on the burden of showing that they did not cause or create it, our position is that this court should follow the case of Jimenez versus the City of New York for the burden of what the city must show on a motion for summary judgment, in that when plaintiff states that there is a cause and create cause of action or stated in the complaint, that the city has a burden to show that they did not cause and create it. Our argument is that they did not meet that burden. And for all the reasons stated, both now and in my brief, we would request that the lower court order be reversed.
Thank you very much.
Thank you, everyone.
Take care.
You
Next
too.
matter is Sacman Enterprises versus BOM Chesterfield.
Your Honor, can you hear me?
Yes.
I'm sorry, I think my video stopped working. May it
So
please the
long as
court.
the audio's working.
May it please the court, Your Honor. Eric Garcia for the appellant, Sacman Enterprises, Inc. At issue, Your Honor, is whether it was appropriate for the lower court to dismiss the plaintiff's complaint solely based on an amended business certificate. We submit that this was reversible error and that the lower court's order should be reversed, and that there still remain extensive issues of fact regarding whether Unit G or Unit F is the true owner of the garage ramp at the Chesterfield condominium. In our briefs, we submit 3 main points as to why the lower court's order should be reversed. First, the amended complaint sufficiently pleaded a declaratory judgment action, which should not have been dismissed solely on the basis of an unrecorded business certificate. And 2, that the lower court failed to acknowledge the documentary evidence showing that it had been the appellant who had maintained the garage ramp since at least 1995, which is at the record at R195, and at New York Department of Finance records are at 208, showing that it's been the appellant who's been paying taxes on this garage ramp since it acquired it in 1995. And thirdly, Your Honor, that the amended business certificate, which was relied upon for dismissal at the lower court, is insufficient to be dispositive in dismissing our declaratory judgment claim because it's an unrecorded document. It's not an instrument for the in real property, and as such, it does not conclusively establish ownership rights over the disputed garage ramp at issue. Your Honor, I think it's important for me just to briefly highlight some of the conveyances which brought us here, because that will show the court that there are still massive issues of fact which were disregarded by the lower court below. The appellant acquired this Unit F initially in 1992, and that's at the record at page 38. And then in 1995, Unit F was then transferred to a creditor of the appellant, Amsterdam Development Corps. That's at the record at 44. Then I'm advised by my clients, Your Honor, that in 1995, a settlement agreement was entered into in the bankruptcy court of the Southern District of New York, which allowed for the creation of a new unit from this original Unit F to create a newly created Unit G, which would preserve the garage ramp, the 2 parking spots, and a storage space. And that was done by the filing of an amendment to the condo deck, which is at record 48, and then by a correction deed, which is at record 52. So this was all done in 1995.
Wait a second,
Then,
counsel. This is Judge Scarpula. What happened to 1991 when you assigned, what happened to the assignment of partnership interest in 1991 where Sackman assigned like 99% of his interest to a non-party, right?
yes, Your Honor. Look, the document,
right?
the document.
Then in that document, it says Sackman no longer has any authority, power, right, or obligation without the prior written consent of the other partners with respect to the partnership, right? So you gave it all up. You gave it all up. You went, here, take my 99.8%. I agree, and I signed a document that says, I agree, I don't have any more ability to affect anything with respect to the partnership.
I understand that, Your Honor.
Do you deny
However,
that document?
I do not deny the existence of that document. However,
isn't it?
however,
Isn't that document essentially the end of the case?
No, Your Honor, because I think that after that, we had acquired the unit that initially had the parking ramp in 1992. That's in the record. That was after the fact. So if you look at record 38, we acquired.
How did you acquire it? How?
By a deed from the sponsor in 1992. So we had. So we had the.
There's a deed in 1992, and who signed it on behalf of the partnership?
Let me just.
Who conveyed it?
The grantor, the sponsor.
And
It's
who?
Nicholas Brusco and Sackman Enterprises.
Sackman Enterprises, the same Sackman Enterprises who in 1991 said, I don't have the right to do that anymore, correct?
No, but it's the other side as well, Your Honor.
I'm just asking you whether that's correct, right?
Look, I'm not denying the fact that there's this document, it's an amended business certificate, which says, hey, we forfeit all of our rights. But the fact still remains, Your Honor, that we were conveyed this unit, which initially had the parking ramp.
How could you convey the unit if you didn't have the right to do it? How? How could that be a legit document?
Your Honor, I'm just showing you what's on the public record, and I think that's really this is what's on Acris, Your Honor, and this is something that was relied upon by the defendants. And I understand, Your Honor, you're saying that, hey, we forfeited and we waived all of our rights, but the fact still remains that there were conveyances after that 1991, which then started.
Counsel, let me just interrupt you for 1 second. The conveyance is not a legitimate conveyance because you didn't have the right. I can sell the Brooklyn Bridge 80 times a day, but if I don't have the right to sell the Brooklyn Bridge, I haven't sold it. So you can file whatever documents you want, But if you don't have the authority to pass title, you don't pass title. Are we agreeing with that or no?
Your Honor, if you're looking at the grantor, it came
I'm just
from
asking you whether you agree with that proposition, that you cannot pass title to something that you don't have the authority to pass title to.
Under normal circumstances, Your Honor, yes. However, this are special circumstances because what happened was the sponsor who it's purported that we relinquished our rights in 1991. After that, there were a series of conveyances. In 1992, we required Unit F. In 1995, it was conveyed to a creditor called Amsterdam Development Corp., which is at record 44. And then what happened was, under a settlement agreement in bankruptcy court, it was agreed that the parties would allow for the creation of a new unit to be known as Unit G, which would have the parking ramp, the 2 parking spots, and a storage space. And that's record 48 and record 52. A year later, that same grantor, Amsterdam Development Corp., which was, I guess, it was the creditor or the bank that we were dealing with, then conveyed that. First, it conveyed the Unit G to us in 1995. Then, Your Honor, in 1996, a year later, in August of 1996, they conveyed Unit F to Chesterfield Suites, one of the respondents here.
Counsel, what do you do? This is Judge Scarpullo. What do you do with the statement in your document, the amendment that says it is not the intent to confirm or ratify in the prior First Amendment, right? No confirmation or ratification is made of the recharacterization of the parking ramp contained in the First Amendment. So no, there's no ratification to your wrongfully transferring a piece of property that you didn't have the authority to transfer, and you acknowledged it in the ratification. So how do you keep going after that?
Your Honor, I think what keeps me going is the fact that 23 years have transpired since this alleged wrongful doing, but Your Honor, it's all stemming from the same set of facts coming from between 1995 and 1996, Your Honor. And I feel like this property, Unit G, Unit F, was conveyed to the parties in this litigation right now, and it was all done under some type of, bankruptcy proceeding, some type of workout arrangement regarding this bank, but it's coming from the same grantors, Your Honor. And I still think that the passage of time of us maintaining the property.
And counsel, your time has passed.
Okay.
I'll hear from the respondent, please.
Good afternoon. May it please the court, Kristen Pendergrass for respondents, Board of Managers of Chesterfield Condominium and Chesterfield Suites LLC. We respect.
So how do we get past the 1991 conveyance?
You mean the 1992 conveyance, Your Honor?
The 1992 conveyance. I'm sorry. How do we get past?
The basic sequence of events here is the condominiums formed in 1989. There's a declaration. It's this joint venture between.
I understand all of that. So after 1992, does the petitioner Sachman Enterprises have anything to convey? Do they have any interest or whatever in the ramp after 1992?
So they did until Unit F consisted of these parking spaces, the ramp, and the commercial space in the upper floors. In 1992, Sachman acquired the ownership of all of that space. In 1995, again, this is 4 years after they've given up their interest in the sponsor. The declaration is very clear that the only people who can amend, or the only groups that can amend the declaration, are a supermajority of the unit owners, which is not at issue here, or with respect to subdividing the commercial unit, which was Unit F, is the sponsor, and that's it. Sacman gave up its interest in the sponsor in 1991. In 1995, regardless of what agreements they reached with their creditors, they tried to file this purported amendment that moved the 2 parking spaces, the storage unit, and the ramp into this new Unit G. They did not have the right to do that. So that entire First Amendment, that purported amendment in 1995, isn't a valid conveyance, isn't a valid division. In 1996, the board and Chesterfield Suites, as Chesterfield Suites is acquiring Unit F, finds out about this 1995 amendment, which incidentally is also filed in Sacman's name. It's not filed in the name of the sponsor, which is another reason it's defective. Not only did Sacman not have any interest in the sponsor, they also filed it as though they were the sponsor, even though they weren't. But in 1996, the board and Chesterfield Suites finds out about this 1995 amendment that's supposedly to resolve this issue between Sacman and its creditor. None of that's in the record. There's nothing in the record to say how that comes about. They just, the only document in the record is this purported amendment. And, says there's no authority to do this, but because we now have this kind of messy situation where there's sort of a claim of divided ownership, the cleanest thing to do at that point was to just say, okay, Sacman we will say, yes, the parking spaces and the storage unit are Unit G. We'll file this confirmatory amendment to kind of clean everything up, but the ramp is still part of Unit F, or a limited common element pertinent to Unit F. It is not part of Unit G. That's, that document's recorded. Sacman has constructive notice of it. There's no.
Sacman continues to argue that the parking ramp is a part of Unit G.
They have continued to argue that that's been a dispute. My understanding is it's a dispute that's been on and off between the board and Chesterfield Suites and Sacman for a number of years. And it's actually, this didn't come up in the record below, but Sacman actually filed a lawsuit in 2007. There's an easement for the ramp for the adjacent building. There's basically, in order to get to the parking spaces for a separate building next door, you need to cross over the ramp. And so there has been an easement for that ramp. There was a dispute that arose basically based on Sacman allowing people to park on the ramp and, blocking it effectively. A dispute came up related to the easement. Sacman filed a declaratory judgment action in 2007. And at that point, I believe it had happened a number of times over the years, but in terms of legal actions, Chesterfield Suites and the board said, you don't own the ramp. This has come up in less formal settings. This dispute hasn't resulted in legal action a number of times over the years. And Sacman has just persisted on saying, just keeps coming back and saying that they own the ramp, and there's no basis for the claim. As far as the amended business certificate goes, Sacman doesn't actually dispute that it's a valid document. Their only argument for why it was wrong for the court to consider it was that it's not recorded, but it's not a document that has to do with the ownership of real property. It's an internal management document for the sponsor. It's not the type of document you would record. And whether or not a document's recorded isn't relevant to whether or not it can be considered documentary evidence. It's still a contract. It's still an agreement. It's still valid and binding. And so, the rest of our points are in our brief, but I would say that, fundamentally, all of Sacman's claims arise out of this purported amendment, this 1995 amendment that they never had the authority to file. And so that document being invalid and unenforceable based on the terms of the declaration negates all of their claims to ownership. And everything else kind of rolls from there. And when you get to that point, then you see how the lower court couldn't have reached any conclusion other than dismissing the claims based on ownership and then, entering a declaration that the ramp isn't a part of Unit G and isn't owned by Sacman.
Thank you. Any questions? Thank you very much.
Thank you.
Next matter is Brannick International versus HPD.
Good afternoon, Your Honor. May it please the court, David Haberman for the appellant. Your Honor, the appellant respectfully submits that the motion court erred on two issues in this case, and one is in holding that that a summary discharge proceeding could not be brought upon a faulty affidavit of service of a notice of lien, and also in finding that the affidavit of service established proper service of the notice of lien on the building owner, which in this case is a corporation, Brannick International Realty Corp. This department has recognized that under Section 19.6 of the lien law, a party can bring a summary discharge proceeding if the affidavit of service is faulty, if it doesn't support the service, if it's not filed on time. Section 19.6 of the lien law provides that a summary discharge proceeding can be brought for failing to comply with Section 9 of the lien law, which states what the face of the affidavit must state, or if it's not filed in accordance with Section 10 of the lien law, which describes how it should be filed and when it should be filed. But in 146 West 45th Street against McNally, this court recognized that if the affidavit of service is faulty, or isn't filed on time, doesn't meet the requirements under that section, that terminates the notice of lien. And if the notice of lien is terminated, then it's subject to dismissal in a summary discharge proceeding. And in that case relied on matter of Huey's Realty, in which this court dealt with the exact same issue under lien law section 19.2. and said that a summary discharge proceeding was the proper proceeding. Now, the city does argue that, well, those issues weren't directly before the court and offers up the briefs in those appeals. And in fact, the briefs in those appeals squarely support that those issues were before the court. The affidavit on the second issue, so the summary discharge proceeding is a proper proceeding where the affidavit of service is faulty and service is faulty. In this particular case, the affidavit of service by the process server states that he attempted to serve the owner and the owner could not be found, and then he resorted to posting. And the owner is a corporation, and the process server mimics the language of Section 11 of the lien law, which provides for service on a natural person. It's very important to see the distinction. There are different service requirements for service on a corporation, which is what we have here. Service on a corporation.
Counsel, this is Judge Scarpullo. Wasn't it also served by certified mail?
The affidavit of service states that there was a certified mailing to a particular address, which is
the last known place of business.
Well, actually, it doesn't say that. It says 230 West 101st Street. And if you look at the affidavit of service itself, which appears in the record at page 47, it just says that a copy was mailed by certified mail to Brannick International Realty Corp. at 230 West 101st Street. The lien law 11 states that
was that the last known place of business?
Well, only the city can answer that question if that was the last known place of business. But we say equivocally it's not, because Brannick was filing with the Department of State, and this is in the record, they were filing with the Department of State 2688 Broadway as its business address and address designated for service of process. We're not saying that they didn't have an office at this other address. but the world is on notice that they are doing business from 2688 Broadway. But more important,
Well,
the
counsel, let me
affidavit.
just interrupt you a second. Don't you acknowledge that you have an office at 230 West 101st Street?
Yes, we don't deny that.
So there's no doubt that it was served by certified mail to a place where you were doing business.
Your Honor, the issue is
I'm just
whether.
asking, yes, I know you want to tell me what the issue is, but first just answer me whether or not you were served by certified mail, as the affidavit of service says, at a place, 230 West 101 Street, where you had an office, a business office. Is that all correct?
We said there was an office, and the affidavit says there was a certified mailing to that address.
Okay.
But in this case, the issue is under the lien law, the proof has to prove what the term used is such a service. And an affidavit has to be provided showing such a service. And such a service is to the last known address. And if you look at this affidavit, it does not stand on its own. This affidavit only says there was a mailing to 230 West 101st Street. It does not say the last known place of business. So it does not support on its face the proper service that it's required to support. And the lien law, filing a lien, it's a creature of statute, and it has to be strictly enforced. And a strict reading of Section 11 of the lien law is that the affidavit of service has to show such a service. And such a service has to show that it was mailed to the last known address.
Let me just ask you this one question. You're saying that it is not sufficient to say that the affidavit of service to actually list the last known place of business. It also has to say those words, last known place of business?
Absolutely, because the affidavit of service itself, the affidavit
as a factual matter, it is the last known place of business. You're saying the
I would say not.
Of those words.
No, I would say not.
The affidavit of service ineffective?
No, one, yes, the affidavit of service is ineffective, but I would say it's not sufficient.
That's your argument.
I'm sorry, Your Honor.
Was that your argument, that I could put the actual last known place of business, but unless I use the words, comma, last known place of business, the affidavit of service is no good?
It's defective because it does not stand on its own to show that service was proper as prescribed by Section 11 of the lien law.
Is it better to actually state the address than to put the catch-all phrase, last known place of business?
Oh, you have to have both.
Come back and say, well, how do you know how do we know where exactly you served? How do we know that was the last known place of business?
Well, that may be an issue down the road for a hearing, and that may throw us into a defense in a foreclosure action.
Well, that throws us to your adversary. You may proceed. BC. Oh, who do we have here? HPD.
Yes, good afternoon, Your Honors, and may it please the court. My name is Wamaka Gibi, appearing on behalf of New York City's Department of Housing, Preservation, and Development. The lower court properly dismissed appellant's summary discharge petition for two independent reasons. I'm going to turn to the second one, which you were just discussing.
Is there anything in which would lead us to believe that the statute, it has to specifically state those words?
No, Your Honor. There's absolutely no case law in this court or any other New York court that says that the proof of service needs to explicitly write the words last known place of business. And there's every indication in this record that this address 230 West was the last known place of business. The three key record citations are 19, 28, and 31. 31 is the deed of the property in question, and Brandick itself says that its corporate offices are at 230 West 101 Street. The affidavits, two supporting affidavits, which the appellant put forward in the petition, explicitly go into detail about how this address is an active business address they've been using from 1981 to 2000, which includes the year that service was made in 1998. They go out of their way to say that their CEO and president was actually at this address every other day of the week. They were trying to show that there were places within the city that HPD could have served, and they've proven effectively that this was an address where service was proper. The purpose of the requirement.
But your adversary did state that they had made certain filings with the state which showed a different address.
That's right, but there's no case law that Section 11, the last known address is only the address filed with the Department of State. That's just not a requirement. The Department of State, people can file for different reasons for receiving process serving, but the Section 11 is about an active business address to make sure the corporation receives the notice. And I just want to be clear that this is not a new fact. Again, it was introduced by the appellants themselves, which proved that service was.
This is Judge On. I don't mean to interrupt you, but I have a quick question. We have a lien here. It was, according to my notes here, the lien was renewed twice, right? Once in what period? Once it was 2012 and another time in 2018. Correct?
Yes, that's correct, Your Honor.
Right. So that. The way I see it, if there's this whole argument here that the petitioner is arguing that you never served the lien properly back in 1998, right? The fact of the matter, you have a lien and you've renewed it twice, with the second renewal not expiring until 2000. I mean, I would assume that you renewed the lien, they extended the lien in 2018, so you got to 2028. Can you serve him now with the notice of lien without a problem? Do you follow what I'm saying? That this whole argument about, they didn't serve me, let's just assume arguendo that he's correct, that we didn't serve him, that you didn't serve him. You've extended your lien to 2028, so you can technically serve him now, right?
Your Honor, I'm not sure about that exact response. I believe that the lien law does require that service be made within a certain period of time from when the lien is actually filed. Okay. So I think that time may have expired.
Okay.
I just wanted to note one correction in our brief, which we pointed out to opposing counsel before they had filed the reply. On page 6, Mr. Lopez was HPD's process server, not a full-time employee of the department. Turning to the first issue as to whether Section 19.6 was actually a proper vehicle, the Court of Appeals recently affirmed in Rivera that Section 19.6 is limited to only 3 grounds for obtaining summary discharge, and a defective service is not on that list. I want to correct a few things that appellant said. That Hugh, as you can see for 2 different reasons, did not deal with the issue of Section 19.6. First of all, there was a factual hearing in Hugh, which the lower court describes in its opinion, which makes it clear that it wasn't actually a summary discharge position proceeding. It was a factual. Witnesses came forward and talked about whether service was proper. So we know that Hugh is irrelevant to this case. Second, in Hugh's brief, the Leany's brief, they discuss on page 28 and page 44 about how their argument is that the lien law, Section 11, is self-executing. And so they were not actually using Section 19 as a vehicle for discharge. It was just a completely different argument. And so it's unfortunate because Hugh has been relied on by the court in McNally and in Second Department cases to advance this argument where it really has nothing to do with this issue of Section 19.6. The McNally brief is also clear that the parties did not discuss whether Section 19.6 was an appropriate vehicle for the dispute. It was discharge was granted under that section, but neither party looked at the question of whether a service defect was one of these 3 enumerated grounds. Argument is that the parties didn't really focus on that issue because the service defect was clear and it was undisputed. And we think that this McNally was wrongly decided on this particular question because the parties just didn't address it. The court had no reason to look at that issue. And McNally spawned some of these Second Department cases which appellants rely on. key distinction between those cases and the case at bar is that in all those cases, the service defect was clear, obvious, and most of the time it's not contested. Here, for the reasons we outlined in our brief, HPD properly served. And so we think that on those two independent bases, this court should affirm.
Thank you. Any questions? Thank you both very much.
Thank you, Your Honors.
Last case for argument is CSC Holdings versus Samsung Electronics.
Good afternoon, Judge. James
Good afternoon,
Patterson.
Mr. Patterson. You have 7 and 3.
Thank you very much, Judge. And thank you for considering us. I know it's late in the day. James M. Patterson for Arnold and Porter K. Scholler on behalf of the appellant Samsung. Your Honor, I know you've heard this before. This is actually a very simple case. Samsung had no obligation to indemnify Cablevision where the infringement it claims it's liable for was due to products that Samsung didn't develop, didn't manufacture, didn't sell, and I suppose most importantly, didn't get paid for. The contract here is extremely simple. It's on pages 895 through 833 of the record, 133 of the record. It was signed in January of 2010. Only really 4 paragraphs of the entire 8 pages are implicated on this appeal. Paragraph 1, sale and purchase. Under that paragraph, we sold to Cablevision set-top terminals and the software to make them work. That's all we sold. So that frames the dispute. The other paragraph that's implicated throughout this entire appeal is paragraph 19, which is intellectual property indemnification. Under that paragraph, we were obligated to indemnify Cablevision for everything that we sold to them. There are 2 additions to that broad indemnification, and these aren't really disputed. The first is if there's a modification to the box that we sold, Cablevision needed our written consent to that modification before it would trigger the indemnification obligation. The second is that if Cablevision combined our box, our set-top box, with any other product or technology that we didn't sell to them, Cablevision once again needed our written consent to that addition before our indemnification obligation was triggered. It's uncontested on this record that Cablevision actually did both. By 2015, Cablevision, let me just explain, the technology is really not at issue here, and you don't need to understand any of the technology terms other than the most basic. The box that we sold is described in Schedule A. It's on pages 104 to 106 of the record. It's uncontested that those boxes had no recording capability whatsoever. We sold a box that when you press channel 30 on the box, channel 30 would show up on your television. And I'm willing to wager that everybody on this bench probably has one of those boxes in their house. That's all the box did. It had no recording capability. It had no rewind capability of any type. That's what Cablevision bought from us.
Counsel, this is Judge Scarpula. Are you saying that you had, so there's software that makes the rewind and the other modification. Are you saying that Samsung had nothing to do with that software?
Samsung had nothing to do with that software other than, well, let me just back up. That software was developed, produced, and the dongle thing that's referred to repeatedly in the brief.
Isn't Cablevision saying, let me just cut you off for a second and saying, isn't like, before you even sign this agreement, isn't Cablevision saying to you, we need these modifications to the software? How can we do this? Let's work together, because we're not buying just your straight up set box, which isn't even defined. I looked throughout the agreement to see if I could find what set top means. You've defined everything in the world but set top. But I mean, it's clear. This is not like Cablevision comes in with its own, like separate software that has nothing to do with Samsung and says, and runs it. And then TiVo says, and you negotiate a deal with TiVo, by, and the only thing you cut out is Cablevision. So it's not quite the simple, we had nothing to do with this, right?
Actually, Judge, Unfortunately, virtually none of that is correct. Page
Oh, okay.
179 of the page 179 of the record. It's Exhibit 12 to the complaint. We told Cablevision you can buy the box with recording capability, or you can buy it without recording capability. Guess which box they bought? They bought the box without the recording capability. There is no question about it. And in terms of where set-top boxes are defined, this contract actually has virtually no defined terms as a commercial division judge would know it. There's a collectively referred to as Samsung products, but Schedule A and Attachment A to the contract, without any question whatsoever, says that the boxes don't do anything to do with recording or rewind playback. It is Schedule A and Attachment A to Schedule A. By 2015, Cablevision had contracted not with Samsung. Cablevision contracted with Zodiac to implement both of these technologies. They didn't contract with us. They didn't pay us to do it. And then they combined them with the Cablevision box. At that time, they were obligated to get our written consent if they wanted indemnification, and they didn't get it. So we moved to dismiss. Now, you can read that complaint as many times as you want, and they devote approximately 50 paragraphs to proving, in their view, that they complied with the express condition precedent of written consent. Now, every judge on this panel, because I looked last night after I found out who the panel was, every single judge on this panel has held, some of you over a dozen times, that an express condition precedent must be literally performed. You have all held that. Of course, it's the Court of Appeals holding in Oppenheimer, the 1995 Separate decision. There is no writing alleged in the complaint that Samsung ever gave written consent to the incorporation of the remote storage DVR network or the rewind buffer. It's not there. So we moved 3211 to dismiss. It's clear under every case that we cited in the brief that they have the burden. The plaintiff has the burden of establishing literal performance of a condition precedent. That means they need to show in the complaint that we gave them written consent to both the remote storage DVR network and the rewind buffer. It is not there.
They alleged it though, right? This is a pre-answer motion to dismiss and they allege it, correct?
They allege it as a legal conclusion. You're only required to accept the factual averments in the complaint as true, Judge, just like any other 3211 motion. You're not required to accept their legal conclusions as true. If that were the case in New York, then of course you could never move under 3211.
No, but I mean, did you move under 3211A1 or 3211A7?
3211A1, Judge.
Oh, you said there was documentary evidence that
Sure, there is nothing there, Judge. There are emails between Cablevision people and, as you know, Judge, we were required to provide tech support under Section 7 of Attachment A. Section 7 of Attachment A says that we have to provide tech support for, and I'm quoting it, testing, integration, and successful launch of the cable boxes. We did that. There's no question we did it. If you accept Cablevision's interpretation of Section 7, that because we had Samsung employees working at Cablevision Central, it would completely eviscerate the indemnification exceptions and the express conditions precedent contained in Section 19. Similarly, Cablevision says that we had the obligation to procure the license from TiVo. And I know you brought that up in your question, Justice Scarpula. The problem with that, of course, is that the motion court and Cablevision has studiously ignored the first 5 words of Section 2 in Attachment A. Those 5 words are, except for Cablevision supplied software. We had no obligation to provide licenses from TiVo for Cablevision supplied software. It's uncontested on this record. It's uncontested in this complaint. In fact, they plead it in the complaint that they paid Zodiac to develop the software to make both of those technologies work. They didn't pay us to do that. So we had no obligation to provide a license for TiVo. We had no obligation under the tech support to do anything other than testing, integration, and successful launch of the box. It's completely uncontested in this complaint. Now, the motion court simply refused to do a 3211 analysis for two reasons. First is the novel proposition that CPLR 3015 prevents that from happening. There is no reported decision in the state of New York that agrees with that interpretation of 3015. 3015 stands for the very unnovel proposition that the plaintiff has no burden to plead the satisfaction of a condition precedence in derogation of the common law. Having pled it, though, and having pled it through half of their 100-paragraph complaint, it's as susceptible to a 3211 motion as anything else. So the court just got it dead wrong, and there is no case that says anything to the opposite. The second,
Mr. Caddison, I'm sorry, I have to stop you now. You'll have time for rebuttal. Thank you.
Thank you, Judge.
Mr. Mark? Still muted. There you go. I'm enthralled by Mr. Caddison's argument concerning the lack of documentary evidence in support or in opposition to the 3211 motion. Can you address that?
Well, Your Honor, the in our complaint, we do allege in great detail the terms of the contract and the material that we say gives meaning to what are, frankly, ambiguous provisions in the agreement between Samsung and Cablevision. My adversary immediately veered into an argument having to do with a lot of facts about what these boxes do or don't do and how they operate or may operate. But let's go back and remember that this is a claim for breach of contract, and in particular, an indemnification clause. And one thing that's important is to start with, what was it that TiVo asserted here? It appears at page 147 of the record. And what they accuse here is the set-top boxes. The language is specifically the Samsung set-top boxes deployed in the Optimum service, that's the cable service, are unlicensed. It was the boxes that were alleged to proclaimed to be unlicensed under the TiVo patent portfolio. Now, when you go and look at the indemnification clause of the agreement, it says if any claim is brought against Cablevision, alleging that and I'm doing ellipses here for a little bit. If any claim is brought against Cablevision, alleging that the use of the Samsung products infringes any patent or other intellectual property rights of any third party, then there is indemnity.
So, counsel, this is Judge Scarpula. So you're telling me if it turns out in discovery that what TiVo really meant was the set-top boxes with your separate Zodiac software, that you're not entitled to indemnification?
Well, I can't
That's
indeed.
basically what you're saying. So then we'll wait for discovery. I mean, that's pretty simple. We'll ask TiVo, what do you mean by that? If they mean just the hardware, then you've got a good indemnification claim. But if they mean the hardware plus your separate Zodiac software, then you're out. Is that what we're agreeing to?
I don't think it's as black or white as that, Your Honor. No.
Rephrasing what you just said.
Yeah, but only in the it's not as black and white at that in the following sense. I could posit a situation where there could be some allocation between different pieces of hardware, software, and whatever contributing to this. But the accusation here is made that the boxes are what infringed.
Clearly, look, I'm willing to go with that if you want to say that on the pre-answer motion to dismiss, but clearly TiVo doesn't care about the hardware. TiVo cares about your Rewind and other Zodiac software that you've moved in, that they say is their proprietary software. So as long as we're all on the same page, all you have to do, counsel, is do one interrogatory to TiVo and say, what do you mean by that? And if their answer is, we mean that extra software that connects the rollback and all the rest of it, then you've just conceded you're out on that indemnification claim.
Well, I don't think it's that simple, partly because.
Well, what's not simple about it?
Because if you look at other documents that we have attached to the complaint, which are writings coming from Samsung explaining the working relationship here, and in particular, I'm referring to material at exhibits 11 and 12 to the complaint, you will see that in 2010, as this product was being developed, there was a understanding between Samsung and Cablevision, and the author from Samsung is Steve Goldstein, not some little person who's from nowhere, but the guy mentioned in the agreement as the person who notice goes if you need notice. What these show is that there was discussion between Cablevision and Samsung that Samsung knew it was putting forward a box that would support RS-DVR.
That's not the same as written consent to indemnifying you for property that it didn't develop and it got no payment for. Why did it do that?
And I also thought the argument was that you were given the choice between a box that recorded and a box that did not record, and that you selected the box that did not record.
That's a factual assertion that counsel has made here. I don't think that would be borne out once the proof comes in. The material that I'm referring to, which appears in those parts of the record at exhibits, mostly at exhibit 11 and 12 to the complaint, talk about this functionality of rewind. And what's significant there is the following, that there is an understanding that is reflected in those exhibits to the complaint that show both parties were discussing different ways to support this functionality called RS-DVR. Mr. Catterson referred to things we all know, like video on demand, or you turn on your box and it comes out.
This is Judge Scarpula. Discussing stuff doesn't equate with I have written consent. Yes. That I have consented to indemnify you with stuff that I didn't create and I didn't get paid for. I mean, why would they do that unless there was a written consent for it? So what do you consent? What do you say is the written consent?
Well, what I say is the material I say reflects that are writings reflecting written consent are the exemplars of it are the material that's attached to the complaint. But let's focus on what the written consent must go to. The written consent in paragraph 19 it refers to consent to modification of the equipment. It's not, I promise to indemnify, it's, I know I'm producing a piece of equipment that does this. The language is, if the alleged violation would not have occurred but for modification of the equipment or associated software made by Cablevision without Samsung's written consent. So the consent is to, do I know the box that I'm producing? And the answer is yes. Significant here also is exhibit 13 to the complaint, which appears about page 184, 185 of the record. I'm sorry, Justice Harper, were you saying something?
I'm saying it says that yeah. I will only indemnify you. And clearly here, this infringement claim came up only because of your modification. And your modification, not Samsung's modification, yours. And so it says, if that's the situation, it's not ambiguous. It says, if that's the situation, I have to, Samsung, agree in writing that I will indemnify you. Where is that? That's right. All I'm asking.
If it is a modification, and we think there's a dispute about that, but that's for later. If there is a modification, the consent has to be, it would be phrased this way. Does Samsung know, did it write that it knew that it was modifying this box to support RS-DVR?
No, that's not what it says. It says modification to the equipment or software made by the indemnified party, which is you. So the question is, without written consent. So right. Again, I say to you, that's straightforward. There's nothing ambiguous about it. What do you say is the written consent?
In exhibit 12 in particular, and I'll point you to pages 177 and 178 of the record, there you will see there emails in which are written by Samsung discussing the product they are developing, talking about.
No, that's not the same as written consent. I can talk all day about something. Where does it say, and I consent to indemnify you for this new piece of equipment that's gonna, clearly it did, it wound up starting an infringement claim by TiVo. Where does it say that in that document? Discussing is not enough. That's not even close to being enough.
It's not merely a discussion. It is a consent to create a product and make a box that does this function. And the emails that I refer to you show that Samsung knows it was making a box that would do this. Indeed, Exhibit 13, page 184 to 85, this was so well known that the entire industry, indeed the whole world, knew it was doing this. It is understood that Cablevision Samsung boxes won't come with onboard DVRs, but will instead be capable of supporting the multi-service operator's upcoming network-based remote storage RS-DVR service. Why would Samsung do it? Here's the industry assessment. The deal strengthens Samsung's position in the US cable industry. They want to sell millions of these boxes, and they did. TiVo then comes after us, years later, by the way, saying, your box is not licensed. That's what they accused. And what we then find out at that point is that Samsung has previously cut a deal with TiVo to get a license to some and not for others. It didn't have a license to any of the boxes, apparently, that it was selling. That is what I'm inferring from the way this deal was done. So the point is that as Justice Masley found, you have these very broad terms in the contract. Any use of the Samsung product, of associated software, infringes any patent and so forth. They come at us and say, the box is accused. We turned around and said to the person who sold us that box, back it up like you said you would in this master sales agreement, and they didn't. That was the breach of contract. We similarly say, under the procurement clause that has broad language, it will be responsible for the procurement and royalty payments for all intellectual property rights associated, very broad term, with the use of the set-top. We think those very broad terms encompass this. Now, what they have to show is that
counsel, you're telling me that you can go to somebody who has nothing to do with Samsung and get software to use with your product, and you think Samsung has the obligation to go out and pay royalties for that third party that has nothing to do with Samsung? You think that's the deal?
Importantly, we don't allege that's what happened here.
No,
we say
isn't that what you just said?
We say in paragraph 58 that the box was not modified in any way beyond what they knew or expected in the system. This box, remember, it's not something that you buy and use as a doorstop, okay? The only thing this box does is to connect your video screen to your cable service, and it interprets the signals that come in, and lo and behold, you have cable on your TV. So of course, its only thing is to be used. So that, and we can all posit hypotheticals that go way beyond the limits of what could be contemplated. But that's the problem with this agreement. Because this language is so capacious, it cannot be shown unambiguously to exclude the claim that we make here, and therefore the case should go forward. We believe we will be able to show that this is within the terms and so forth. I assume that Samsung will try to contend that there were things that went beyond and so forth and are outside. But that's not something that can be decided on the motion to dismiss. And we believe that we put in additional material sufficient to show that.
Thank you, Counselor. Your time is up. Mr. Catterson, you have 3 minutes.
I'll try to do less than that, Judge.
Thank you.
Let's just start with Cablevision's position on what constitutes written consent. My adversary said repeatedly, look at pages 178, 179. Look at pages 178, 179. That's an understanding that Cablevision conveyed to Samsung, and Samsung knew it was going to build these DVR-capable boxes. There's a problem with that. They're all pre-contract negotiations. In fact, on page 179, it says explicitly that we offered a hybrid DVR to Cablevision and they didn't buy it. Those are pre-contract negotiations. Cablevision knows there's a merger clause in this agreement. So any understandings that they may have had before they executed this agreement are irrelevant. There's no possible way that this court could ever find that some pre-contract negotiations about what they might be doing, or as my adversary just said, an industry assessment of what Samsung might be doing, could constitute literal performance of an express condition precedent requiring a writing. It's impossible under this court's precedent. Discovery. Discovery will show nothing in this case. The entire universe of information with regard to the issue of written consent is before you. They devoted 50 paragraphs of a 100-paragraph complaint to demonstrate to you and to the motion court that they literally complied with an express condition precedent. You can read that as much as you want. You will find no mention from any Samsung employee in writing or otherwise after the execution of this agreement that we consented to the modification or that we consented to the combination of the rewind buffer. It is not there. The last point about the TiVo claim. 149 of the record, page 73 of the record, TiVo's claim as communicated to Samsung is as follows, and I'll quote it. And this is by Cablevision. A number of patents related to DVR functionality implemented through the use of the set-top boxes provided by Cablevision, provided by Samsung to Cablevision. Justice Scarpula, you got that right. TiVo wasn't suing over the boxes. They were suing over the software and the hardware developed by Zodiac. It is absolutely clear on this complaint, we're entitled to judgment that they didn't get any written consent for either one of those. Thank you very much, Judge.
Thank you. Thank you both. That concludes the oral arguments for today, March 2nd. Court is adjourned.
Thank you, Your Honor.